April and a request that you received to attend a meeting at Luthuli House. Can you please tell us about that request?
Yes, I received, my personal assistant was on leave at that stage, so the stand-in personal assistant received a request from Edok Godongwana. That request didn't have within it the topic of any conversation, but it was a request to attend a meeting which was subsequently set up by the secretaries, and I attended that meeting on the 20th of April.
Had you been requested to attend Luthuli House before this request?
Yes, I have attended meetings at Luthuli House before. So, for example, when there was national discourse in South Africa on the nationalization of mines, given the importance of that to our economy and the safety and soundness of our banking system, I presented on Nedbank's view on that as input into that national discourse.
Had you ever been requested to attend a meeting to discuss the closure of Nedbank's accounts with any of its clients at Luthuli House?
No, I hadn't.
And can you tell us when that meeting was held and who was in attendance?
So the meeting was held on the 20th of April. The records that I had after the meeting of my notes showed that Gwedi Mantashe and Jesse Duarte were in attendance. It is also my recollection that Enoch Godongwana was in attendance. However, my notes didn't have that, so I am therefore uncertain as to whether he was or wasn't in attendance. He did, however, set up the meeting.
Thank you. And what was the purpose of the meeting? And what was explained to you would be the purpose when you arrived?
So the purpose that was explained to me was to try and gain a better understanding around the circumstances why banks in general close bank accounts. I thought quite deeply beforehand as to whether I should or should not attend the meeting, and my conclusion was that in the environment at that stage, there were at least two key narratives or discussion points. One of them was around the specific matters of the closure of the Gupta accounts, and I was very clear that I would not be able to talk at all, given client confidentiality, around the specifics of the closure of the Gupta accounts. However, there was an intersecting and growing narrative around more general statements around the bank's ability to close accounts generally. What is the legislative environment around FATF and FICA? What impact is this having on investor confidence? And did the banks collude in closing the Gupta accounts? And I certainly felt that in my capacity as the chief executive of Nedbank, it was very important that I addressed that second narrative around closure of accounts in general, the legislative framework, the impact on investor confidence, and the fact that Nedbank took its own individual decision to close the Gupta bank accounts. I felt that that was incredibly important for the safety and soundness of the financial system in general and for Nedbank in particular.
Were you provided with an agenda for the meeting in advance of it?
No.
And in paragraph 9 of your statement, you, from the second line, record there that you were advised of concerns that had been raised to the ANC from the general population and businesses around the ability of banks to just close client accounts unilaterally. What did you say in that regard at the meeting?
So I explained that in the banking system in South Africa, we compete with all of the other banks to try and grow our businesses and actually to open as many accounts as we possibly can. So banks certainly are not in the business of closing accounts unilaterally. I then went on to explain the broad framework around the FIC Act in South Africa. I spoke in particular about Guidance Note 3. I then also, in that meeting, took the attendees through a particular extract from the JP Morgan Chief Executive and Chairman's report around closure of bank accounts to demonstrate that this is not an unusual activity in a certain set of circumstances.
Thank you. You've made reference to the JP Morgan Chairman's report of 2015. That was an annexure to your affidavit in the Minister of Finance matter, but is not part of Exhibit H1. And so I'd like to beg leave to hand that in, Chair. It will be Exhibit H6 with your leave, if I may request your registrar just to take a copy, and also to the witness. Thank you.
Thank you. Well, while you are looking at that, Mr. Brown, you said that banks are not in the habit of closing clients' accounts unilaterally. Whenever they close accounts, certainly I would imagine, based on what I've heard from other witnesses from banks, when they close them in circumstances such as those that prevailed in regard to the particular accounts we are talking about, they do so unilaterally insofar as they don't consult with other banks, so they don't collude. But also they do so unilaterally to the extent that their decision to close the accounts is their decision and theirs alone, in the sense that it's based on their view, and from what I've heard in regard to the other banks, it's not that they will discuss with the client in advance, but it looks like they make an assessment of the situation and make a decision. But after having made the decision, they don't close the door to the client if the client wishes to discuss the matter. But the decision does appear to be unilateral. What would you say to that?
So I would say that the decision is a decision of the bank. It is a decision of the bank, as I said earlier, based on our assessment of business and reputational risk, as well as our contractual right in our underlying legal documentation. And inevitably, what happens in circumstances such as this, and there are many accounts that we choose to close, in circumstances such as this, we give reasonable notice. And it is during that reasonable notice period that the client has the ability to come and talk to the bank about the reasons for closure. And there are certainly instances where, for example, we are trying to complete for a high-risk customer something that's called an extended due diligence that we are required to complete. And if we are unable to get the required documentation from the client to enable us to properly complete that due diligence, we would give notice. If in that notice period the client delivers the required documentation, and that documentation is persuasive in nature, such that the assessment that we had made prior to having that documentation is now no longer correct, we would overturn our decision to close those accounts.
The only reason I was raising the issue of unilateral with you was that I wasn't sure that you were not contradicting what I thought you intended to say by seeming to run away from unilateral. Because as I understand it, unilateral means simply that it's a decision of one party. It's one side, unilateral, it's one side. It's not a decision you take jointly with anybody, with the client or with another bank. It's just one side, and you take it, as I understand it, on the assessment of the situation as you see it in terms of the reputational risk to the bank. But from what I understand, after you have taken the decision, if the client comes forward and wants to try and persuade you to change it, you leave the door open. But it seems to me it remains that it is a unilateral decision in that sense. It's yours and yours only as the bank.
Chair, that is correct, although that unilateral decision is taken by a broad grouping within the bank.
Thank you.
Mr. Brown, just to pick up on an aspect of the Chair's questions, you indicated in the termination notice to the Gupta-related entities that you were closing those accounts because of reputational risk associated with it, with the accounts. And then there was the meeting that we referred to previously with Mr. Hauer on the 3rd of May 2016. Is it your understanding of that meeting that there were not adequate reasons presented by Mr. Hauer at that meeting to remove the reputational risk that Nedbank regarded as associated with those accounts?
That is correct.
And can you tell us what that reputational risk really means for a bank such as Nedbank?
So the reputation of a company or a bank is essentially how that business is perceived by stakeholders in general. So how we are perceived by clients, employees, competitors, media, investors, regulators, and particularly important for banks would be depositors for the safety and soundness of banks and the system. So probably for banks more than most other businesses, and there would be some that would also fall into this category, and I think here of auditors in particular, reputational risk is extremely important. Our business relies on the trust of members of the general public in the safety and soundness of our bank and the system to enable us to become the custodians of the nation's savings in the form of deposits. So if one thinks through reputational risk, it has inherent in it a level of cascading. It could escalate depending how bad it gets. There is, inevitably certain pieces of reputational risk that would be business as usual, and we would deal with that on a normal basis in the bank. But there are examples of where reputational risk becomes so great to a particular business that has a material and in some instances terminal effect on that business to continue to operate. And I would point obviously to the public examples around the material impacts reputational risk has had on the likes of KPMG and McKinsey's, and the terminal impact that reputational risk would have had on the likes of Bell Pottinger.
Thank you. If I may return to page 206. Chair, was there a question from you? I'm trying to anticipate here.
You are doing well to keep one eye on me. I just want to clarify this. From what you say, Mr. Brown, it would seem to me that your evidence is consistent with the evidence I've had from one, if not more, of the witnesses who have come here and testified about the role of the banks and decisions they took. Now, one of the things they said was that in regard to a specific account holder, you could have, or a bank could have a situation where it considers that it should terminate its relationship with that account holder, not because that account holder has committed or any crime or is in breach of any laws of the country, but simply because there is a certain perception in the public domain about that account holder. Would that be consistent with your understanding of Nedbank's position as well?
So, Chair, broadly, yes. However, I would like to amplify a few issues there. There would certainly be accounts that sit on international sanctions lists that would automatically be closed.
Yeah.
And in respect of the perceptions, I think certainly we take a lot of time to try and understand where the underlying news flow comes from, and therefore, as a consequence, how reliable that is likely to be. So if I went back to my previous examples, you know, there's clearly an enormous amount that gets put out on social media that would have a lot less, it would have some weight, but a lot less weight than, for example, a statement coming out of the Ministry of Finance, as we saw in March, or the resignation of auditors or sponsoring brokers.
So it would be a taking into account of everything you consider relevant to the bank's reputational risk, and how much weight you attach to any particular factor would differ from one case to another, with the result that maybe in some case, somebody who has not actually breached any laws of the country, you might close the accounts because there nevertheless is some serious reputational risk. But in other cases, somebody who has not breached any laws but has some reputational risk to the bank, you might decide on balance not to close the accounts. It would just depend on the view you take of everything. Is that right?
That's correct. That's why we manage these decision processes through committees at the bank, which enables input into that decision from a legal perspective and from a business perspective. Perhaps also important to add is that we would not only consider the reputational risk up to that moment in time when we take that decision, we would also be forward-looking in respect of the potential future reputational risk and how that could escalate. And in particular, in respect of this set of circumstances, Nedbank was not the main transactional bankers to the Gupta entities, and it would have been a concern to us that if all of the other banks had closed the transactional banking facilities with the Gupta entities, we could have by default become their main transactional bankers and therefore inherited an escalating level of reputational risk as a consequence of that.
Thank you.
Mr. Brown, if we can go to page 206 of Exhibit H1. In the top paragraph on that page, you conclude your description of the meeting at Luthuli House with members of the ANC. And you reference there the Breedenkamp case. How did that come up in your discussions?
So, as I said earlier, in my discussions, I made it very clear that I could not talk about matters related specifically to the Gupta-related accounts. But what I felt was important was that I spoke about the legal framework in general around the closure of bank accounts, and of particular relevance there is the FIC and the related guidance note, as well as the Bredenkamp judgment, which, and I'm not a lawyer, but which essentially, in my understanding, said that a bank Standard Bank in that case, is entitled to close the Bredenkamp accounts as a consequence of the reputational risk that Bredenkamp posed to Standard Bank, and in particular what that may mean for its international and other banking relationships.
And Mr. Brown, can you give us a sense of your impression of that meeting at Lutuli House? Did you understand the meeting to be designed to place pressure on the bank to reopen the Gupta-associated accounts?
I did not leave that meeting feeling that I was placed under any pressure to reopen the Gupta accounts. And in fact, the meeting closed with me being thanked for providing information that was helpful in understanding and answering questions that the attendees get.
Thank you. If we can then move to page 202 of Exhibit H1. You will see that there is an introductory section on that page and then a heading, Interactions between Nedbank and the IMC. That, as I have it, is shorthand for the Interministerial Committee that you referred to previously. There were public announcements of it having been constituted on the 13th of April 2016. And if you can go to paragraph 2 on that page, talk about an event on the 4th of May 2016 where your executive personal assistant received an email from Ms. Zarina Kellerman. Please can you tell the Chair about that email?
Yes, Chair. It was an email that I received that said, I write to you on behalf of the IMC, set up by Cabinet to look into certain allegations made against certain financial institutions. The IMC consists of the Ministers of Mineral Resources, Finance, Labour and Communications. I've been requested to make contact with Mr., they said William Thomas Brown, but I presume they forgot the Michael, or alternatively a suitable alternate with requisite authority, and request that he makes himself available for a discussion with the IMC on Thursday, the 5th of May from 12 to 12:30. There is no set agenda for the discussion, but I am advised it is anticipated to be a discussion to gain clarity on the current media reports and public statements made by Nedbank with regards to closing the bank accounts and or termination of the closing of bank accounts and or termination of relationships. Should Mr. Brown not be available in person, a teleconference could be accommodated. And then there was some admin around the dates could move. And finally, should Mr. Brown not be willing to participate, please advise me accordingly so that I may indicate the same to the IMC. I look forward to your response.
Thank you. I'd like to unpack some of the details that you've provided us with there. First of all, the ministers who were identified as constituting the IMC. I'd like us, just for clarification purposes, to identify who the people were who held those ministerial positions at the time. The Minister of Mineral Resources, who was that?
Minister Zwane.
The Minister of Finance.
Minister Godaan.
The Minister of Labour.
Minister Oliphant.
And the Minister of Communications.
Minister Mtumbani.
And can you tell me whether you had received requests like this previously to meet with representatives of government?
So I've certainly received requests to meet with representatives of government, largely representatives of National Treasury around banking and banking system related matters, but I had certainly never received a request to attend an interministerial committee. In fact, I had to try and find out what it actually was.
And when you've had those meetings previously, where have they generally been held?
So I've attended meetings with government in Parliament. I've attended meetings with government at the Ministry of Finance in Pretoria or at the Reserve Bank, by memory.
Thank you. And just for clarification, when you referenced the Minister of Communications, were you intending to reference Minister Mutambi?
That's correct. Sorry, my pronunciation was incorrect.
Thank you. In terms of the notification that was given to you about the purpose of the IMC meeting that you were called to attend, at paragraph 2 on page 202, there is a reference there to the purpose of the discussion being, and I quote here, to gain clarity on the current media reports and public statements made by Nedbank with regards to the closing of bank accounts and or termination of relationships. Did you regard that as being a broadly focused purpose for the meeting or specific in its nature?
So I think in the first instance, I regarded it as being quite a strange statement because I knew at that point in time, Nedbank had not made any public statements given client confidentiality around the closure of these accounts. But I certainly assumed that there would be a conversation around accounts in general. That would have, I suppose I knew that in attending any of these meetings, I would not be able to speak about the Gupta accounts specifically, so therefore I would only be able to provide general input into that meeting.
Where were you told that that meeting would be held?
So the meeting was held at the offices of the Minister of Mineral Resources in Pretoria.
When you provided us a moment ago with your recollection of where you've met previously with members of government, as I recall your testimony, you referenced Parliament, you referenced the Minister of Finance's offices, and you referenced the Reserve Bank. Have you ever previously had occasion to meet at the offices of the Minister of Mineral Resources in relation to banking matters?
No, I haven't.
And what was your response to the request for the meeting?
So similar to the request of the meeting from the ANC, I debated and spoke to colleagues internally about whether I should or should not attend, given some of the strange elements that you have recently alluded to. And again, I concluded that I should attend on the basis that I would not make any statements or references around the Gupta accounts specifically, but as an engaged corporate citizen and as a leader in the banking environment, it was important for me to make sure that I could input into these conversations my views around the bank's ability to close accounts, the processes that we follow generally, the legislative process, to reference the JP Morgan report that we spoke about earlier, and to very specifically point out that there was no collusion amongst the banks in this process. So on balance, I felt that it was appropriate for me to attend. I also felt it would be disrespectful not to attend, but that I would make sure that the conversation was in that second area of the narrative and not the accounts in particular.
And did you regard it as strange that the meeting was to be convened at the Minister of Mineral Resources in Pretoria?
So I did regard it as strange. However, when I was given up front who the members of the IMC were likely to be, One of those members was the Minister of Finance, who I thought would be the natural go-to person for matters to do with financial services. So I suppose presumed that, I assumed he would be in attendance and felt perhaps that was just the most logistically easiest place to get the meeting done on that day.
Precisely who attended was of concern to you, wasn't it?
It was of concern to me.
And so what did you do in that regard?
So prior to the meeting taking place, my secretary emailed as to who would be in attendance, and the first email listed all of the ministers in the IMC, including the Minister of Finance. And then, if you give me a minute to find it, I think there was then a subsequent email to say that as a consequence of it being an ad hoc meeting, they could not at that stage confirm the exact attendance.
Yes, maybe I can give you the reference. If we go to paragraph 3 on page 202,
Yeah.
what you say towards the bottom of the page there is that Ms. Buckley, your personal assistant, confirmed your attendance in an email to Ms. Kellerman on the 5th of May and requested her to confirm that the Minister of Mineral Resources, Minister of Finance, Minister of Labour, and Minister of Communications would be in attendance. And then in the next sentence, which is over the page at 203, you record, and I quote, Ms. Kellerman responded advising that she was unable to confirm exactly which ministers would be in attendance due to it being and I think this is what you referred to, an ad hoc sitting. I'd like to pause there. What did that mean to you?
I suppose at that stage it meant to me that this was either an initial sitting, a sitting that had been set up in contemplation of a number of future sittings that would take place, and or a sitting that had been set up at relatively late notice to get a process going, that it wasn't one that had been planned, meticulously in advance.
And then you go on in that sentence to say that Ms. Kellerman provided assurance that, and I quote, the committee will be appropriately represented. What did you understand that to convey to you?
Well, so I presumed that any committee set up like this would have within its mandate a quorum, and that when I got to the meeting, that it would be appropriately quorate in terms of its defining mandate.
Thank you. And then further down on page 203 at paragraph 4, you talk about the meeting, which you attended on the 6th of May. Can you please indicate who attended the meeting with you from Nedbank?
So from Nedbank, I was accompanied by Ms. Anna Isaac, who is our Chief Legal Counsel, and Mr. Tico Thomas, who is the Managing Executive in charge of our retail and business banking operations, which is the client-facing business within Nedbank that housed the Gupta-related accounts.
And who attended on behalf of the IMC?
So perhaps just give me a second and I'll give you that.
If you'd like to look at page 203 of your statement and paragraph 4 there, yeah. You indicate from the 4th line who was attending on behalf of the IMC.
So page 203.
Paragraph 4.
Yeah.
And so, then from the end of the 3rd line.
Thank you. So the attendees were Minister Zwane, who chaired the meeting, Mrs. Kellerman, who acted as secretary to the meeting, and Mr. Herbert Mkhize, who joined the meeting as Minister Oliphant's representative, and then 2 other people who joined the meeting but were not introduced, and I assumed that at least one of them was representing the Minister of Communications. Ministers Oliphant and Godin were not present, neither was the Minister of Communications.
Thank you. You then indicated paragraph 4 that you raised a query about the quorate nature of this meeting, and you've referred to that previously. Why was that of concern to you?
I think it was of particular concern to me because I expected, given the nature of the meeting, for the Minister of Finance to be present, given that it is the Finance Ministry that has overarching oversight of the financial services sector and banks in particular.
And what was the response when you raised that concern?
So I was assured by Minister Zwane that the Minister of Finance was aware of the meeting and that we should continue, given his previous response that the meeting was quorate.
Have you gained any subsequent insight as to whether the Minister of Finance was in fact aware of the meeting and had delegated his authority to Minister Zwane for the purposes of it?
So I have no subsequent insight of that other than having read numerous documents, and I believe there is a letter that forms part of one of the bundles from the Minister of Finance where he disputes that.
Right, if I could just take you to that. That is in Exhibit H1 at page 144. That we heard from Mr. Sinton, who gave evidence on Monday, was a letter that was made available by the Minister of Finance in the course of the litigation in the High Court involving the Oak Bay companies and the pressure that had been exerted on the Minister of Finance in relation to securing a reinstatement of those accounts for those companies. If you look at this letter, it is headed from the Minister of Finance, and over the page it appears to have been signed by him. Of course, Minister Gordhan will be giving evidence to the Commission in due course and no doubt will be asked to confirm these aspects. But for present purposes, you will see at the bottom of page 144 that, well, let's start above. He bullets 5 points there in relation to the constitution of the Interministerial Committee. In the second paragraph, and I quote, he writes, "As you are aware, I was not present at the Cabinet meeting you refer to, but I have consulted the Cabinet Secretariat on the matter. The following emerges," he says, and if you wouldn't mind reading into the record the 5 points that he makes in relation to this Cabinet meeting in a letter addressed to Minister Zwane.
So the letter says the following emerges. The Cabinet meeting was on the 13th of April 2016, not the 16th of April 2016, which was a Saturday. Point 2, no interministerial committee was established. Point 3, 3 ministers were nominated, Finance, Labour, and Mineral Resources. 4, no one minister was designated as convener. And 5, the financial services sector is not, in quotes, already distressed, close quotes, as your letter indicates, and care must be taken not to compromise financial stability.
And then if we could just take a look at the last paragraph on that page. As I read it, Minister Gordhan concludes the letter with the statement, "In the circumstances, it will be advisable for the 3 ministers to first consult on the framework for any discussion with financial institutions." What do you make of that request from the Minister of Finance in relation to coordination with his office for the purposes of engaging with financial institutions?
So I would understand that to be the minister in his capacity as having oversight for the financial services system to, prior to having any engagement, wanting to ensure that this would be a well thought through, pre-planned engagement in the context of the legislation around anti-money laundering, etc.
Thank you. If we can return to page 203, which is back in your statement.
So sorry, just to be clear also, clearly at the time that I attended the IMC, I was unaware of this letter. Indeed. Notwithstanding it predating the IMC.
Indeed. Thank you for that clarification. Mr. Brown, you referenced a at the top of page 203, your engagements with Ms. Kellerman and her response that she couldn't give you more details about who would be in attendance because she said, quote, it was an ad hoc sitting. When you did convene on the 6th of May, was the meeting introduced as merely an ad hoc sitting of the committee?
I can't specifically recall whether it was introduced as a sitting or an ad hoc sitting.
Thank you. And if you then go down to paragraph 5 on page 203, I'm going to jump ahead slightly in the chronology because what your statement does at this paragraph is it actually jumps ahead to what you did after the meeting. But I'd like to follow its order and then return to what was discussed because we are currently dealing with the theme of who was present at the meeting. And so it's appropriate to deal with what you say in paragraph 5. As I have it, you record the steps you took after the meeting to confirm those who were in attendance. Please can you explain that to the chair?
So, Chair, as I said earlier in my evidence, there were a number of people in the meeting who I was familiar with. There were also 2 people who were not introduced at the meeting. So I felt it appropriate to get a full listing of who was in attendance so I would know who those people were.
And if we go to page 207, that is Annexure A to your statement. As I have it, that is both your request in the second half of the page. Will you please read into the record what you requested?
So this was requested by my personal assistant, and she requested, please, to Zarina Kellerman, please can you email me the full names and titles of government that attended today's meeting? Thank you.
And then if you look above that, there is the response, as I have it, from Ms. Kellerman on the 9th of May. And what does she record there as who does she record there as the attendees of the meeting?
So, Chair, the response says, apologies for the delay. The team consisted of the following. Mrs. Faith Mutambi, I'll get that right by the end, Mrs. Faith Mutambi, as well as her advisors, Mr. Mzwaneli Manyi and Sandile Nene, Minister Mildred Oliphant, as well as her advisors, Mr. Herbert Mkhize and DDG, Mr. Virgil Seafield, Minister Zwane and his advisor, Advocate Zarina Kellerman, who was the Secretariat.
Was that an accurate recordal of who attended the meeting on the 6th of May with yourself?
No, it was not.
And could you identify the respects in which it was inaccurate?
I can, to the extent that I am aware of that. So firstly, Minister Mutambi did not attend. Her advisor, Mr. Manyi, did not attend. I'm uncertain of whether Mr. Sandile Nene was or wasn't one of the unidentified attendees that I said earlier. Minister Oliphant did not attend. Her advisor, Mr. Mkhize, did attend. I am also uncertain whether DDG Seafield was or wasn't the second person from the prior discussion. And then it was correct in the fact that both Minister Zwane and Advocate Kellerman were there.
Thank you. I'd now like to move to what was discussed at the meeting, and that is at page 203 of your statement. And it commences at the bottom of the page at paragraph 6. Can you take us through in your own words, but happily with reference to what is contained from paragraphs 6.1 to 6.7 over on page 205, what was discussed at the meeting?
So the meeting opened with Minister Zwane advising that the IMC was required to submit a report to Cabinet by the 11th of May, and therefore these meetings needed to be held expeditiously. And off the back of that, I read into the reason for the ad hoc meeting that we spoke about earlier. He also up front expressed dissatisfaction for some banks that had refused to attend. I did not know at that stage if any banks had or hadn't refused to attend, and stated that it was concerning that banks could undermine government by refusing to attend such meetings, and I certainly felt that that was a veiled threat in terms of the power of the IMC. He said that the meeting was a confidential meeting, and I had the impression it was being recorded, given that both the Secretariat was taking notes and there was equipment. I don't know whether the equipment was switched on or not from a recording point of view. Minister Zwane started by saying that the IMC was constituted by Cabinet and that it was not there to represent any particular family or company, but rather to resolve the apparent issues of investor confidence and reported potential job losses that had emerged as a result of banks closing bank accounts, and that those job losses were in thousands. I recall the number he mentioned in the meeting was 16,000. And I certainly up front in the meeting confirmed that while we were happy to engage on matters broadly around closure of bank accounts and legislation, we would not be engaging at all around any specific matters on the Gupta accounts, given banking confidentiality. I then spent a large portion of the meeting going through the regulatory environment, in particular Guidance Note 3, and I listed a number of the issues that exist in Guidance Note 3 around what banks are required to do in terms of knowing their customers, risk rating their customers into high, medium, and low, what are indicators of higher risk customers, and banks' reporting obligations under either cash threshold reporting or suspicious transaction reporting. I also specifically spent time going through the JP Morgan report, where JP Morgan disclosed publicly that they had closed 18,000 accounts in their prior period as a consequence of reputational risk, and also the legal risk they run if they make a mistake.
Mr. Brown, if I may just take you then to Exhibit H6, which we handed in previously. We handed it in at the point that you referred to having made reference to it at the meeting at Luthuli House. But here in your statement, you also record that you made reference to it in the meeting with the IMC. We've marked it Exhibit H6. And if you would please indicate to us the aspect of that report that you shared with the IMC.
So, Chair, I would have started on the second page of H6, and if you go just about halfway down the page on the left-hand column, I would have quoted JP Morgan having said that they, during the course of the financial review under review, because this is an extract from their public integrated report, that they deployed new anti-money laundering systems, which is a monitoring platform across all of their global payment transactions. It's now functioning across the company and utilizes sophisticated algorithms that are regularly enhanced based on transactional experience. JP Morgan reviews electronically $105 trillion of gross payments each month, and then on average 55,000 transactions are reviewed by humans after algorithms have identified any single transactions as being suspicious. Following this effort, we stopped doing business with 18,000 customers in 2015. We are also required to file suspicious activity reports. I presume that is the US equivalent of our STR reporting. And for JP Morgan last year, they filed 180,000 suspicious activity reports, and they estimate that the industry as a whole files millions each year. We understand how important this activity is, not just to protect our company, but to help to protect our country from criminals and terrorists. I then would have continued in particular to say, JP Morgan exited or restricted approximately 500 foreign correspondent banking relationships and tens of thousands of client relationships to simplify our business and reduce our risk to anti-money laundering or AML. The cost of doing proper AML or KYC, know your customer, diligence on a client has increased dramatically, making many of these relationships immediately unprofitable. But we did not exit simply due to profitability. We could have maintained unprofitable client relationships to be supportive of countries around the world that are allies of the United States. The real reason we exited was often because of the extraordinary legal risk if we make a mistake. In many places, and he's talking about around the world, it's simply impossible to meet the new requirements, and if you make just one mistake, the regulatory and legal consequences can be severe and disproportionate. I think what's also relevant is, probably one paragraph further down to say, in all cases, we carefully tried to get the balance right while treating customers fairly. And I certainly felt that that was a very well set out framework for what takes place in banks globally and here in South Africa.
And is it reflective of what happens in Nedbank?
Well, certainly the numbers of transactions and amounts are significantly smaller given the relative scale, but it is reflective of what happens in the industry and in Nedbank.
Thank you.
With regard to those transactions, are you able to give some picture of how small that scale is in regard to Nedbank transactions or accounts which you close, generally speaking, in order to deal with reputational risk?
So I don't have the specific numbers with me, but my recollection is that in the year to June 2016, which was the last data point, 2017, which is the last data point I can recall, Nedbank would have closed approximately 100 accounts as a consequence of reputational reasons. There would be a significantly larger number of accounts that would have been closed for other reasons like dormancy, etc.
Yeah. Okay, and I don't know to what extent you may or may not have an idea. Is that close to what you would think some of the major banks also might have, or is it quite too difficult to say in terms of how much in South Africa, how much of that happens in South Africa in terms of banks? I see that maybe in the US it's quite large, but are you able to say? You are not able to say?
So, Chair, unfortunately, I wouldn't have that data for our competitors.
Okay, thank you.
Thank you, Chair. If we then go to paragraph 6.4 on page 204, and just to locate us, you told us previously in your testimony that when the meeting began, Minister Zwane gave you an assurance that the purpose of the meeting was not to represent any particular family or company, but to talk broadly about issues of investor confidence. Mr. Brown, did he hold true to that assurance?
No, as you see here, the several questions, not only from Minister Zwane, but from also other members of the panel, were also posed into the specific circumstances. There were questions around consistency. There were questions around what had been the triggers for closing these accounts.
Sorry, and when you say these accounts, is this now a focus on the Gupta-associated accounts?
That is correct.
Thank you.
And a conversation that is recorded here about a Nedbank staff member talking to a client of Nedbank about the Gupta accounts. It's a conversation I wasn't aware of prior to this meeting, but that clearly wasn't in the spirit or in the framing of how this was constituted.
And did you learn how they had come to know of this particular conversation?
I do not know how.
And how did you respond to the allegation that there was a staff member of Nedbank who'd spoken to another financial institution about the closure of the Gupta accounts?
So I responded by saying that I was unaware of these allegations, that they were new to me. I then said that the only context that I could think they could have taken place in is a context of Nedbank talking to other financial institutions with which we have a correspondent banking relationship, and as a result of our normal conversations in us doing our due diligence and anti-money laundering reviews on those clients of Nedbank, it would be normal to have that conversation. And I said that I would, however, try and understand from when I went back to Nedbank as to exactly what the underlying conversation was, which I was able to do, and I subsequently addressed a letter to the IMC that confirmed that the IMC's allegations to us that the Nedbank employee was inappropriately talking to Nedbank clients about Gupta-related matters was in fact not true.
Thank you. And were the accounts of any other families discussed at the meeting?
No.
If we then go over the page to 205, you then reference at paragraph 6.5 what Minister Zwane then said in relation to the Nedbank Gupta entity relationship. Can you please explain to the chair what he conveyed to you?
So what happened in the meeting is that Minister Zwane referenced that Nedbank were not the main transactional bankers to the various Gupta entities. I do not know where he got that information, but he then went on to suggest that would Nedbank consider stepping in to save jobs and provide an amicable solution, given that the relevant family had, in the period between when we gave notice and held this meeting, resigned from those companies.
What did you make of that request to you?
I found it particularly strange.
And what was your response to it?
I reminded Mr. Zwane that we were not here to discuss specific client matters.
And if we just go back to his suggestion that Nedbank step in to save jobs and provide an amicable solution because family members had resigned from the companies, would that provide an adequate basis for Nedbank to reinstate the accounts that you had closed?
Absolutely not.
Why not?
Because our decision for closing the accounts was based on the reputational and business risk associated with those accounts, and that reputational and business risk would not have changed, or not materially have changed at all, as a consequence of resignation of directors. The underlying companies were still in existence and operating.
At the end of paragraph 6.5, you deal with the question of collusion amongst banks. Please tell us what was discussed in that regard.
So my recollection is that there was a conversation around the seeming timing of all of the banks closing accounts at the same time, and as a consequence of that, was there collusion in the closure of accounts? And I refuted that, saying we had not had any conversations with any of the banks around closure of accounts.
And then at paragraph 6.6, you talk about how the meeting concluded. Can you tell us about what happened at the conclusion of the meeting?
So at the conclusion of the meeting, we were thanked for our attendance, and Minister Zwane commented that he found it surprising that other banks had refused to attend the IMC meeting with government, considering that banks receive their licenses from government.
What did you take that to mean?
I also found it to be a very strange statement. I think it felt like a form of a threat. It is also a technically inaccurate statement because banks do not receive their licenses from government. They receive their licenses from the Reserve Bank, which is constitutionally an independent body.
At paragraph 6.7, you reference that it was agreed that Nedbank would be provided with a draft set of minutes for the meeting. Did that occur?
No, we were not provided with a draft or final set of minutes, notwithstanding our request for one after the meeting.
And at paragraph 7, and Chair, this will conclude my questions for the witness, unless there's anything further for you. You talk about your overall impression of this meeting with the ministers at Minister Zwane's offices. What was that impression?
So I think I left the meeting with the impression that the IMC was focused on two key issues. Firstly, to try and determine if there was collusion amongst the banks in the closure of bank accounts. And secondly, to determine whether Nedbank would have appetite to step in and become the primary transactional banker for the Gupta group of companies.
And just for clarification purposes, at paragraph 6.5, the discussion around the relevant family, can you just clarify for us which family that was?
The Gupta family.
Thank you. Those are our questions.
Thank you. Mr. Brown, in that meeting with the IMC, you said that there was a mention of job losses which were said to be in thousands. As at that time, did you understand those job losses to refer to any specific entity or not? And if your understanding was that they were talking about job losses relating to a particular entity, what entity was that?
So my understanding at the time would be that it was job losses associated with a particular group of entities, being the Gupta-related accounts, and that was an estimate of if the Guptas were unable to have banking facilities and therefore as a consequence these companies closed down, that was an estimate of job losses.
Now, when you spoke about the meeting that you had with the ANC, you made it clear that when you came out of that meeting, you had no feeling that you had been pressured to try and reverse the decision of the bank. The discussion had been in general, as I understand it. Excuse me. In regard to the IMC meeting, did you have the same impression?
No, I did not.
And do you want to just articulate again what your impression was as you left the meeting?
So I certainly left the meeting with the impression that a good outcome for the IMC would have been for Nedbank to agree to take over the transactional facilities of the Gupta family, something that we were clearly not prepared to do.
And the impression you had, was it one that made you feel that there was pressure being placed upon you, or simply that maybe there was an attempt to persuade and no more than that?
So again, I think this is relatively difficult on a continuum of pressure to persuasion,
that, yeah.
but I certainly felt that the numerous references in the meeting to the licensing regime was pressure that was being placed on the bank.
You see, because it is conceivable that somebody may come before this commission and say that the discussion was intended for nothing more than just a general discussion. That's why I'm asking you these questions. So maybe it might be good if you say, if you just mention all the things or features of the meeting that together may have given you this impression.
So I think primarily the conversation was being led by the chair of the meeting, which was Minister Zwane.
Okay, so maybe my question was not as clear as it should have been. What I would like you to say, and you have said part of it, is just to say what you would say if somebody said, you are wrong to think some pressure was being placed on you to change the decision. I just want you to say, I would stand by that statement if that is what would be the position because of A, B, C, D. Or if you say, look, it's nothing more than my impression, that's fine. I just want to be able to, I just want you to deal with what I think may well come up later on so that we know whether you feel strongly that that was the position or it's just an impression. I just want you to be able to deal with that adequately.
Thank you, Chair. So I would say that what caused me to believe that there was being pressure placed on the bank would have been a combination of the references to the licensing regime and beneath that the subtext around, you know, be careful, things could happen to your license if you don't behave in a particular way. And secondly, the closure of the meeting, which effectively was a request for Nedbank to become the primary transactional bankers for the Gupta companies, given that other banks had terminated.
Did you say you didn't attend the meeting with Mr. Howard?
That's correct. I didn't attend, but officials from the bank did.
Yes. And I assume they would have given reports to you. Would those reports have revealed that basically in that meeting, the bank did give information to Mr. Howard that it could not give to third parties to say, this is why we have made this decision, and therefore they had the opportunity to say that that's true, that's not true, or whatever?
So, Mr. Chair, my information is that the meeting with Mr. Howard was a very short meeting. The meeting was concluded probably in a matter of minutes. The intention of that meeting was to deliver the notices of termination, which contained within them the reasoning for termination being, in our opinion, the level of business and reputational risk, and as a consequence, therefore, the termination in terms of contractual clauses, and that initially Mr. Howard didn't want to receive those notices. We actually had to subsequently deliver them via registered post, and his only request was for the bank not to make any public statements, which we hadn't done. So I don't believe we had the opportunity in that meeting to explain more than that, given the very short nature driven by him, not by us.
Okay, thank you very much.
Mr. Brown, if I may just clarify there, and I fully appreciate that it's difficult for you not having been an attendee at those meetings, but the description you've just given about the wanting to hand over the termination letter and the resistance to that, as I have it from your affidavit, was the meeting that was held with Mr. Nath originally. Your evidence previously was that that occurred on the 7th of April, and that it was short in the terms that you've described because he was not willing to take over those letters of termination. As I have it, the chair's question related to the subsequent request from Mr. Nazim Hawa to meet with the bank. As I have it, that was in a letter of the 14th of April, which you received as a bank on the 19th of April. And then the subsequent meeting with Mr. Hawa took place, let me just get my note here, on the 3rd of May 2016. Can you just assist us there with the nature of the meeting with Mr. Hawa and what was discussed?
Thank you. Your sequencing is absolutely correct. Apologies. I was answering in respect of the meeting with Mr. Nath on the 7th of April. In respect of the meeting with Mr. Hawa, again, it is difficult for me because I didn't attend the meeting, but it is my understanding that that was a meeting where there was a much broader discussion around Nedbank's termination, a conversation around the reasons, and an attempt to persuade Nedbank to reverse that prior decision.
And as I have it, the outcome was that Nedbank did not retract its prior decision.
That is correct.
Thank you, Chair. And then the final follow-up, just in relation to your questions previously to the witness, in relation to the possibility of further evidence before the Commission. My learned leader at the commencement on Monday indicated that notices to implicated persons had been sent out, flowing from the statements. Those were the statements of Standard Bank and of Nedbank, which the legal team viewed as raising implications for persons. And so specifically in relation to Mr. Brown's testimony, due notices were sent to Minister Zwane, and at present there has been no application for cross-examination or any other application from Minister Zwane.
Okay, thank you very much. Mr. Brown, thank you very much for coming to give your evidence. I will excuse you for now. Should there be a reason for you to be asked to come back, the Commission's legal team will be in touch with you and request you to come back. Thank you very much, and you are excused.
Thank you.
It looks like this might be the opportune time. Mr. Pretorius, you want to say something?
No, we understand it's your preference to use all available time, Chair, but in this case, we have to set up overhead projection facilities, and the witness is not here at present. He was due to arrive in time for 11:30 hearing.
Yes.
So may we adjourn may we adjourn for 15 minutes then? Just to allow the setup to take place.
Yeah, 15 minutes is normally for tea time. Are you sure that's enough for setting up?
I'm told so, yes.
Okay, all right, all right. We are at 11:05 now. So let us resume at 11:20.
Thank you, Chair.
We adjourn.
All right.
In fact, I'm sitting there in the corner now. No, definitely. Yeah. And Paul, I might not sit for the rest
Joburg? Sure.
I think I'm hungry.
I want breakfast. Actually, ele aqua. Ele aqua. Ele nele muna. It's not.
So he doesn't look too close to the camera.
It does. I want to get one.
And now I can see. Ushibile wabona how
Okay. They're on the DA story.
yes.
They've just gone on the DA story.
How long?
That interview is only starting now.
Did you no, that's too bad. We are on a tea break, then we'll go back in session that way to us. So 5 minutes to us is just too late.
I can hear the program, yes. Yes, I can hear the program.
Gloria, there's 7 minutes left. Ne?
Then maybe
I'm gonna decide whether we should cancel or not. Yes. And she knows this. I don't know why it's so. She knows. But provide a full feed. It's not. If it was a simple thing, we could have just done it outside. But we are providing feed for all media, so we can't do that. But I told her, I explained to her. Got it on WhatsApp. Text. Hi, Auris. It literally has to be short. My only concern is we're providing proof. So, we.
If anything happens, what one?
And if not, we're going to pull the key.
The way they listen to you. Child. If anything happens to it, I'm in trouble. You don't get a chance. Watch one.
Sorry. So they'll probably just ask you like 1 or 2 questions. It's just going to be very short.
Is it? Okay.
So are you going to take the slides? What slides? Guest or is I'm going to I'm not sure if we're going to use that screen. But I'm hoping it will be that screen. Like Tammy can take it.
But it's all, I don't know if one screen is used, all of them, they want to say anything.
No, this is our feed.
Yes.
Tammy,
So, libat longa screen for you.
how about the slides? Well, you count to 5.
1, 2, 3, 4, 5.
7, 8, 9, 10.
Please count again.
1, 2, 3, 4, 5.
Are you back? I'll be back. I need to go.
Yeah, and then maybe one of the correspondence I is able to take care of this. He is becoming desperate, and then this guy is asking me, I need to credit. Because I want to see the correspondence. When are you? One of these guys.
Indeed, Tulas, the confirmation here that is being brought to bear by the Chief Executive of Nedbank, Mike Brown, is essentially the confirmation now by all of South Africa's 4 major banks that all of them were summoned to Luthuli House to essentially go and explain why they had closed the Gupta accounts, of course, with the exception of one bank, and that being FNB, which decided that it was not going to attend that meeting. But the impression that we got yesterday was certainly that they possibly were going to attend. It's just that the meeting was cancelled, according to Johan Berger. But the question, the central question here to us is that what was the ANC's business anyway of the governing party to try and intervene, if you like, or at least glean the reasons why the banks were conducting such action against the Gupta accounts. But the more menacing meeting for Mike Brown of Nedbank, Tulas, was the meeting that would have been held with the Interministerial Committee that was chaired by the then former Minister of Mineral Resources, Mosebenzi Zwane. And essentially, there are 2 elements there that he says he really felt that he was being threatened as an institution, and that was if it doesn't help the Gupta family, well, their license could be in jeopardy as a bank if they agreed, or if they were agreeable to try and help the Guptas, then they would become, quote unquote, the transactional bank for the Guptas. And Nedbank was saying that they simply would not agree with something like that because reputation is paramount for banks in South Africa.
This realization now.
Exactly. And he was saying, we'll go by
the realization.
and we'll go by
Wait, it's gonna fall.
No. It's arrangement dead camera operators. Right, Scotty?
Hey, your own arrangement.
Okay, but we must make sure.
No, technically none of us should be, right? But
Thank you.
Yes, Ms. Norman.
Thank you, Mr. Chairman. This witness is Dr. Daniel Kaufman, and I'd like the Chairman to have regard to Exhibit G1, which is his joint statement together with Dr. Hellman. But I would ask the Chairman to swear the witness in.
I'm sorry. You want this bundle to be marked G1?
It was marked already, Exhibit G1.
Oh,
yes.
It's just that the one in front of me is not marked.
Yes.
Or it doesn't appear to be marked.
It doesn't appear to be marked, yes.
Okay. Thank you. The registrar can swear the witness in, please.
Please state your full names for the record.
Daniel Kaufman.
Do you have any objection with taking the prescribed oath?
No.
Do you consider the oath to be binding on your conscience?
Yes.
Do you swear that the evidence you will give today will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God, yes.
Thank you.
Thank you very much.
Thank you, Mr. Chairman. Dr. Kaufman, is it correct that you, together with Dr. Hellman, testified via Skype on the 31st of August 2018 to this commission?
Yes, this is correct.
Is it also correct that you are in possession of the transcript of the proceedings of that day?
Yes.
And have you gone through that transcript? Do you record that the evidence that's contained in that transcript is evidence that you gave?
Yes.
Thank you. On the last occasion, you did indicate to the chairperson that in response to some of the questions that you would want to elaborate when you come to South Africa.
I'm sorry, before you proceed,
Yes.
I thought you would follow up with another question.
Yes.
In the light of the fact that at the time when they testified, they were thousands of kilometers away from here, that you'd ask him. Let me ask him,
Yes.
do you confirm that the evidence that you gave at the time via a video link is true and correct?
Yes, Mr. Chairman, I do confirm that.
Thank you.
Thank you, Mr. Chairman. On the last occasion, then, you indicated in response to some of the questions that you would want to elaborate when you come to South Africa and testify. Just one aspect which I would like you to just confirm, which I do not recall that you confirmed according to the transcript, that you are actually an economist and a social scientist. Am I correct?
Yes, that's correct.
And having read your statement, having looked at your transcript, and having looked at the material that you provided, I decided on my own to come up with a presentation which I would like to show, and then you would indicate to me whether you believe or you want to elaborate on some of the things that I have recorded on that presentation. With your leave, Mr. Chairman, may I beg leave to present to you the presentation, which is entitled, if I may just open it, "The State Capture Phenomenon, Where Business Becomes the State." Could you just move on, or maybe even at that point, would that coincide with your understanding of when a state is said to have been captured, that would be those instances where business would become the state itself?
Thanks. And Mr. Chairman, a comment on this. That's a very powerful title for a presentation, and that's noted. In terms of the approach and the work which we have done for decades with Professor Hellman, who is not here before you today, these would be an extreme manifestation of state capture when the business become fully the state. That, however, should be also noted that state capture could have other forms and could come in more subtle ways. The way we define it is the ability of certain very powerful influencing group, usually from the private sector, to shape the rules of the game that basically make the state function or not. So it's shaping the institutions, the rules, the policies, the laws and regulations governing the state, which could come in various forms. An extreme form is when it becomes the state itself.
Yes, thank you. And then the next...
I'm sorry, before you proceed, it might be helpful if the witness would just refresh everyone's memory of some important features of the evidence they gave before.
Yes.
I don't know to what extent what you have will reveal that, or whether it's just a continuation.
No, in fact, I wanted to start with what you're suggesting, but
Yes.
the witness preferred that we start this way. We will deal with all of those very, very critical features of his evidence.
Okay, all
Thank you. Okay. And then the second slide having taken from various countries, having taken from various authorities and various publications, where we've listed possible persons that may be, or entities that may be captured. You see that, this second slide? Are you there?
Yes.
Yes. And that in certain countries, it may be the president of that country, in certain countries, the ministers, it may be officials, it may be councillors, it may be the judiciary.
That's correct.
Okay, thank you. And then on the third slide, we deal with intermediaries and enablers. This is something that you did not touch upon in your evidence when you testified on the last occasion. It was mentioned briefly that there would be many players in the industry. But then what I've identified from your evidence is these intermediaries, enablers can be many and not easy to identify. But they are important facilitators of state capture. Some private accountants, financial and tax advisors, international traders, lawyers, etc. So why is it difficult to identify the intermediaries and enablers?
Well, the challenge is one of doing the proper in-depth diagnosis for each country. If and when that is done, and a number of countries have embarked on this process, and you're one, it should be possible to identify those intermediaries. But by definition, because of the nature of state capture, they tend to operate in the shadow, and there are many preconditions for basically shedding light on that shadow. I can refer that to it later as we go through the transcript, and you may have detailed questions regarding particular cases and how long it may take until all of this is unearthed. But with the proper political will, resolve, and then technical work and investigative work, it is possible to unearth and identify who these enablers are. It's very important to recognize that between the captor, that those that seek to shape the laws, the regulations, and the policies of the state, and those that are captured, they are very important facilitators and enablers. It's not done just between two parties. Usually it's a complex web, and doing the proper diagnosis that will vary from country to country, but it is possible.
Yes, thank you. And then you've already mentioned the capture, which is on this next slide. Which should be the entity, the person, or the firm that would have control over the intermediaries, enablers, and may seize public power, influential business people, particular economic conglomerates, military, etc.
Yes. That's indeed the case.
Yes.
And in some settings and countries also, the mafias, drug traders, very powerful illicit economic interests play a role. In some others, it could be some part of the more traditional economic or financial elite. So it will vary from setting to setting.
Yes, thank you. And then the next slide is, these are the potential sectors that you've identified in your report. not all of them, but some of them as being the sectors that can be captured, being the extractive and the mining sector, the industrial sector, energy, financial, communication, and military. Is that correct?
That's correct, and that, again, I want to stress, take this opportunity, Mr. Chairman, to stress the importance of acknowledging the particularities of this challenge in every country. And that's one of the reasons I commend your commission and the work that it is doing. But nobody can come from the outside and have a particular template or Bible that says where it all happens. As the expression goes, to use, if you allow me, a bit of lightness, why do so many robbers are interested in robbing a bank? It's because that's where the money is. Well, it's a useful, simplistic approach to start looking at this issue. When one does a diagnosis within a country, it will depend where the sources of major rent for that elite would be. In some countries would be the oil sector, which is, we focus in many countries on that, which is subject to capture of the rents. Others is a financial sector. Others it could be both. So it will vary from country to country depending on the particularity of the country.
Yes, thank you. And then I've just entitled matters that you've identified as red flags, so to speak. So you deal with sponsorships and donations, charities and educational foundations, trusts, mismanaged and unduly influenced state-owned enterprises or through privatization, illicit political finance, beneficiary ownership, financial benefits to dependents or family members, monopoly over fishing, mining, energy, communication rights, and financial benefits to the members of the executive from foreign countries. I will take you to some of these later on in your evidence. But is there any particular one that you believe that I've left out from your summaries?
I think this is a comprehensive enough first list. Some further details can come out through the details later. I should stress also that since already it's clear that you are doing very, very important work on that, there may be some features that you have emphasized here, which may be particular here, which we would not have emphasized, and we have not seen it in our previous work. Like you mentioned at first, sponsorships and donations. You would know best how that works here, yes, and whether that's a particular feature. That does not come from our work. Yes. And the only other comment for now, to put it in context, that could be quite unique to here. On the other hand, the challenge of state-owned enterprises being utilized as a vehicle for capture and the distortion of basic policies, the use of public funds and so on, that is quite common in this field, and it's something that is a major challenge that we're trying to help with in other countries, particularly in the oil sector. We have studied that in the context of the organization I lead, but also it's clear in other sectors as well. So that you have mentioned here, it's a challenge that it's quite common in many other countries of how state-owned enterprises do not operate in the best commercial, financial, and economic interests of the country, of the public good, but are essentially part of the captured environment for the benefit of the few.
Yes, thank you. And then the next slide, we deal with administrative corruption as you deal with it in your statement, and regulatory corruption, state capture. But what I would not want you to comment on these, because the questions that I'm going to be asking you later on, they relate to the distinction between these concepts, which we will have to deal with. But you've just summarized your report insofar as those are indicated therein. And then the next slide then is the consequences of state capture. The erosion of the economy, the costs to entire society, that it may plunge country into recession, it may affect poor members of society, destroys competition, it affects countries' borrowing capacity, and it may lead to unemployment and increase of state grant dependency. But I'm going to now, with all of that summary, then take you so that you can put that summary into context. As to when you're talking about state capture, you've already told us what it means, but we'd like you to repeat it now because maybe other people didn't hear it properly when we explained via the video link that the whole concept, you had coined the term state capture together with Dr. Hellman, am I correct?
That's correct.
Yes. And then in simple terms, what do you mean when you say a state is captured?
Yeah. First, Mr. Chairman, and thanks again for this opportunity and to be in person. Here, it is my honor and privilege being before you in person and in your wonderful country. But to give credit where credit is due, we did not invent the term capture, and we did not invent all what is in this framework. But as it's usual in academic work, we studied in depth the previous literature as well as the reality as we saw it on the ground. As well, we're serious believers in evidence-based analysis, evidence-based advice, and evidence-based policymaking. So we did a lot of surveys to collect data about the situation. A lot of credit goes to other writers in the well in the past, but particularly one Nobel Prize in economics, George Stigler, who wrote first about regulatory capture. And it did encompass the sense of very powerful interest being able to influence particular regulations in an economy. So that already had been developed. What we did is pick up on that, but broaden it. And I think that's a clarification, if you allow me to make it very broadly here, because I know that this is a legally oriented commission, which is commendable, yet it's very important to understand our concept beyond only the laws, the legal aspects of that. The concept that we developed, and we made it very clear, is the shaping of the rules of the game in a particular nation by those influential few. We use usually, but not always, illicit means to do so. And these rules of the game, by these rules of the game, we mean the laws, yes, included, but not only. And in some countries, that's mostly expressed through the implementing regulations and other such regulations. So it's the laws, the regulations, the policies. What happens with macroeconomic policies and so on? There's a lot of discretion in any country within the constitution and within the existing laws, yes, yet they can be captured. The allocation of public expenditure, what happens in state-owned enterprises, whether the procurement system is rigged or not, could still be in a context where the constitutions and the laws in the constitutions were not necessarily unduly shaped by that particular captor elite. That could have started very well, but it's in the context of these policies and regulations and institutions that are captured that these could happen. So in that sense, I want to draw the distinction and the broadening of the term from the original notion of regulatory capture or even legal capture. We were very narrowly focused on that to make it broader to also encompass all policies, implementing regulations, as well as institutions, a key institution in the state.
Yes. Seeing that you've already touched on regulatory capture, could you define for us, because this is an aspect that you deal with in paragraph 7 of your statement, you deal with administrative corruption, you deal with regulatory corruption. Could you just define those, because there seems to be a very fine line between the two, and also to make it easy for one, when you present it with facts at the end of the day, to see whether this is indeed regulatory corruption or administrative corruption. Could you just deal with those two concepts?
Okay. As already suggested, but elaborating on that, Mr. Chairman, administrative corruption takes place when there is bribery or related illicit action that basically provides a private gain and a private benefit to one individual in the implementation of a particular regulation or a particular law. If I have accumulated certain sanctions for being drunk, for drunk driving, or trying to get rid of parking ticket violations, and I pay a bribe, or for red tape, to try to get around red tape in my company, and so on, and facilitate from my own individual benefit without, which is insidious, and it should not be happening, but that does not necessarily have a major impact throughout society and for the public good to everybody else. That's administrative corruption. And that we distinguish. So that's in the implementation of a particular regulation or norm. If instead we're talking about altering and shaping these laws, these regulations, these institutions, helping influence it and distort them so that ultimately the benefit is for myself or a small group in the elite, and it's usually at the expense of the public good to the rest of society. That's what we're talking about in terms of state capture. And again, I want to make the distinction that's broader than the original notion of regulatory capture, which only focus on particular regulation. But here we're talking about institutions also and about policies.
And then this regulatory corruption, administrative corruption and state capture, you associate, when you title some of the headings, they refer to countries that are in transition. Can we find these in countries that are actually stable, that are old, that are not in transition at all?
That's another excellent question, Mr. Chairman. And before fully embarking into that, just like I gave an example in the case of administrative corruption, as like when there is red tape and one tries to get around the red tape, paying a bribe. A very potent example of what happens with state capture, which doesn't necessarily imply that that somebody shaped the constitution in a particular way. It's on political financing. And the rules, regulations, and the system of party and political finance is something that evolves over time, and an enormous amount of abuses take place in many settings in the world to affect particularly those policies and subsequent laws that are passed through parliament in many countries. So that's an example of how a system can be influenced. The same can happen with, as we said, through state-owned enterprises and through public expenditure and through other such things which have major impact and investment. So now, in terms of the issue of in transition, it's essentially to recognize the notion that countries that have been in transition, the institutions are either more in flux, because they're also in transition, they're evolving, they're being developed, and or they start from a rather weak initial standpoint. And for either of those two reasons, or for both, the vulnerability to being captured in the process, because the institutions are being shaped during those transitions, and the laws, and the implementing regulations, and the policies, there is a higher probability of being amenable to capture. It's very important to recognize also how do we interpret transition. Transition is not unique to what we used to call developing countries, and I'm a proud citizen of a country that was labeled as a developing country. Was it Chile? Now we are a proud emerging economy and part of OECD. Those transitions also take place in very industrialized and very rich countries. Many of us are observing with much concern the transition is beginning to take place, has begun, and will probably have major impact in the case of Britain and Brexit. That's going to be a major transition where many institutions, rules, laws, regulations would have to be reformulated and are going to traverse. So that's the first clarification. Transition doesn't mean developing a country status. It's common in emerging economies. We were in transition, and in some sense, we're just at the end of a very important transition post-military dictatorship in Chile, which was Pinochet until the late 80s. It took a generation to that for that transition to occur. I'm not going to belabor now on the details, but it takes a long time. The Soviet system went into transition once the Red Curtain falls, and in many ways is still in transition. I've come here from Ukraine, still a country very much in transition, where many of the institutions have been subject to this challenge of capture in one form or another. So there's a higher vulnerability in countries in transition, but it's not only. To illustrate a country that has not been in full-fledged transition, with very robust institutions since sometimes in 1900s, after having experienced enormously high and corrosive corruption, is the United States itself. And it took a very long time for that transition to occur. After the Civil War, historically, things did improve. There were hiccups with the Tammany Hall experience of the political movement out of New York and so on. Then there was a recovery and much improvement, but nowadays it's a serious concern, and given the political changes, that some forms, however subtle or not subtle, of state capture have returned, even in the case of the United States, which if there is interest, I can elaborate further later. But it's to illustrate that can also happen in countries which are typically not labeled in transition.
Yes. Then you would get a question from someone from South Africa, where South Africa has, according to South Africa now, as we find it now, has its foundational values entrenched in the Constitution, which we regard as one of the best constitutions in the world. Now, then someone is going to say, but when all the laws were promulgated, all of the laws after 1994, at least, they had to be consistent with the values espoused in the Constitution. So you have that situation then in South Africa where we know that everything has to be constitutionally compliant. How then does one associate regulatory corruption with a state such as South Africa as we find it now?
Thanks. An excellent and a complex issue again that you are asking, and Mr. Chairman, the first thing that I would want to clarify is that the assessment of the situation in South Africa is yours. I'm not an expert in South Africa, so that's of high interest, and I'm of course very interested in informing myself while I'm here on that. So I speak from the experience of other countries. Countries like the United States, some others have very robust also and proud constitutions. There have been amendments because the times evolve, and as times evolve, there's always a need to refresh the legal framework, reinterpret, have amendments, and so on. Just to illustrate, since we just discussed the United States, and also to put it very frankly and clearly that this problem of state capture is not of one type of particular country or economy. It's not an issue for developing countries in particular, or so on. The United States, which has had a very robust constitution, very robust, and then with its amendments, they have had over time interpretations, and it goes, because it's common law, interpretations, they go to the Supreme Court on that, what constitutes corruption and bribery. Under the existing laws, as of 2 years ago, as of a few years ago, what constitutes bribery and corruption, the former governor, and at the time was sitting governor of Virginia, was then indicted, was prosecuted, indicted, and then ended up serving time because of illicit gifts that he had received while in office from a contractor that subsequently got particular contracts. That is appealed, goes up to the Supreme Court. The Supreme Court essentially uses that case to redefine and narrow the definition of bribery and corruption by suggesting that that was not sufficient to prove there was corruption. There had to be a much more direct and totally proven link between the two events, the gift that was provided on the one hand and then the subsequent decision, which is it's considered in the governance field as overly restrictive and draconian, and therefore it would leave many people who are engaged in bribery and corruption with impunity. That's, as an analyst, I'm suggesting that, but the main point here is to illustrate that the laws are a very important institution in a country at a particular moment, but they do evolve even when there is a constitution. So what was illegal up to a year and a half ago in the United States regarding a possible bribery offense, now it's legal. That goes also to the notion that we have explored in the past that bribery can be, or capture, can be done through legal means according to the laws of the moment in that country, which doesn't mean that that cannot change. Conversely, and not to be also fair to many robust institutions in the United States, after the Wall Street crisis, following that major debacle which had major worldwide consequences, and the Wall Street crisis is a case study on capture of the financial regulatory system by Wall Street and related elite. After that, there's a reaction, there's institutional reaction suggesting the robustness and the resilience of the political and related institutions in the United States. As a result, major regulation and legal changes take place in the form of the Dodd-Frank financial sector bill, which makes many things that were legal before illegal in terms of the activities in the financial sector. Again, it's a way of suggesting that these laws do evolve over time, and different groups may have different type of influences on those laws, some through legitimate lobbying and part of the competitive political discourse, but some, they could be undue and it could be going the wrong direction. Unfortunately, right now, there is a movement to undo many of those tighter regulations of the financial sector, again, because of the interests of the financial elite in the United States and the present political environment. Most of it has not yet been undone, and it goes to show that the resilience of the institutions are important. But the point here is that we are in a dynamic context where the laws, the regulations, the policies of every country evolves, even in the context of a very robust initial constitution and set of laws.
Yes, thank you. In your statement, you deal with the issue of governance weaknesses as being some of the causes of state capture. And then could you just elaborate on that and just show briefly why governance deficiencies would cause that or would lead to it?
In simple terms, and Mr. Chairman, thanks again for a very apt question. In simple terms, we're dealing with a complex interplay between the chicken and the egg. First, and you showed it in your summary slide very well, when state capture is present, that those actions by the captor, abetted by the intermediaries, the facilitators, and the enablers, can have major consequences. Some of those consequences are on the broader governance structures of the country itself. In some countries, and it's particularly noteworthy in some countries in Latin America, not the Brazils or the Chiles, who have made much progress, but in others, many countries of the former Soviet Union, the judiciary has been totally totally captured. So the undermining of the governance, the key governance institutions, whether it's in rule of law, in terms of economic management and policy making and so on, takes place as a result of capture. And that would be one of the slight additions I would have suggested in your nice framework that you put it, is not only the social, economic, and other costs you put, but the cost in terms of the governance institutions being weakened and undermined. And let's not underestimate and call it by its name, the undermining of democratic institutions. In countries where that have been in transition, democracy is already dynamic and vibrant, but if a very small elite captures the system, in the eyes of the rest of the population, there is a major loss of legitimacy of those very democratic institutions. And in Latin America, we have had it from time to time, such political influencing inequality that arises. There are talks about military coup against and so on, after having left behind this military dictatorship for a long time, and the appetite then of considering, well, maybe we would not be so bad under military dictatorship if instead the alternative is a completely captured system in the economic and social sense. So I want to stress that linkage. Of course, the other side of the causality direction, the direction from going of weak initial institutions to enabling state capture to occur, it's also present. And that goes to your previous question, why do you focus in countries in transition? When the Soviet Union collapses, in some sense, it becomes almost like a blank check in terms of all the institutions that have to start from scratch, consistent with political competition and democratic institutions, as well as economic competition. What to do with all the state assets that begin to be privatized and what happens to them. So depending how weak those governance structures are at the initial point, that can also influence the extent to which state capture occurs. So essentially the direction goes in both ways. The initial governance strength or weakness of the institutions of the state when a process starts is a very important determinant about the vulnerability to state capture. And conversely, once state capture occurs, that has a very pernicious effect on the further development of the governance institutions in the country.
Yes. From I know that in one of the answers to one of the questions, you've made it very clear that you are not here to talk about South Africa because you have not researched South Africa.
And because
yes,
you know it much better.
Yes, thank you. And then can we then just deal with one other issue that you dealt with in your report at page 38, where you now say once a state finds that, or once there is what is state capture in any state, what are the solutions? I had taken you through this in your previous testimony, but I would like you to give examples to the Commission because you had undertaken to come back and give examples of some of the countries that were found to be in a situation where there was state capture, and what steps did they take to try and redress that situation.
Sure. I can do that. Now, it's very important to recognize how incredibly complex this issue is, and that's why it's commendable what you're doing. And there are pitfalls in just picking a country and suggesting that the whole country is a success. We are in an imperfect world with great leaders, great institutions, enlightened countries in many cases, but also there are other forces, other institutions. So there will be progress in some areas and not in others. There will be two steps forward and one step backward, even when there is progress. But of course, I cannot help if you allow me, to say a few things about the case of my own country in Chile, where first it's very important to study and recognize the historical antecedents in every country. In the Soviet Union, for instance, the Soviet system, in many ways, if we study it with data and very clearly, there was very significant corruption throughout the system, and how the elite, in fact, basically benefited in a very particular ways at the expense of the rest of the population. So it's very easy sometimes to only focus on what happened a few years ago. In Brazil, everybody's focused on what has happened very recently in the case of the car wash scandal and so on. But we have this the understanding and the review of already this has been going on for 20 years, and one has to understand the military dictatorship antecedent and how that had a major impact. In the case of Chile, it is a case that historically there were already enlightened leaders who imparted the absolute paramount importance of serving in being public servants and serving with full integrity and doing away from lack of integrity practices. That was already historical, starting in fact from the first founder of the country, Bernardo O'Higgins, and who becomes the first leader in the country. We're talking about 1812, if you allow me. And one of his first decrees was to order, at that time, the presidential house, it's a presidential palace, but it's not so much of a palace, the outside walls had to be plastered with all the names of the top officials and the high officials and what were their incomes and assets. This is 1812. We're now in almost 2020. In how many countries there's still reticence to do some such basic work? But this is to illustrate that it's very important to go back to history. And then there are many other antecedents where there are problems, but governance improves, and then there are setbacks. And these are setbacks under the dictatorship of Pinochet. The mid-70s to late 80s, and eventually was discovered that there was a lot of corruption, including by the leader of that, and the association with the particulars of the private elite was already a form of capture then. And then major reforms start to take place. And two major findings that we have already with Joel Hellman from our initial work on state capture from the Soviet Union, which post-Soviet countries, we're talking about 27, did better, and which ones went the capture way, which ones went the competitive way. And there's a clear distinction, and I discussed that briefly last time, between the two types. The countries in the Baltics, the Slovenians, and others have gone market, have gone competitive, so it's nothing predetermined, versus countries like Ukraine and Russia, Azerbaijan, and others. So there are two distinct types. Two major issues that come out very clearly as associated with the extent of capture or lack thereof. One, political contestability, the extent that there is a vibrant competition politically, and associated with that civil liberties, the voice of civil society, the engagement of civil society, are they there or are they suppressed? Like in Central Asia, unfortunately, that's the case now, the voice of that. So that's one, the political contestability and competition era. The other is economic contestability and competition. To what extent a vibrant, medium, small-scale sector is allowed to operate, enter, and operate, even if there are large enterprises. Is there enough competition, rather than in the former Soviet Union we call them oligarchs. Is there one or two oligarchs, or maybe there are 20 and 25, and then already competition ensues, as well as the next stage, medium and longer scale. So the extent of that economic contestability, economic competition is very important. And for that, obviously, opening the doors to the rest of the world, having investors and the presence of more global industries also can be very important, although some misbehave in terms of governance and corruption. We can discuss that. But overall, the openness and the competition in that context is very, very important. Then one gets into the details. Those are very large buckets, but obviously the extent to which anti-monopoly regulation in the country effectively works is extremely important to assure competition in the economic sphere. In the political sphere, it's extremely important the extent to which, not only to which there is political competition among parties in a very open, legitimate way, and total open and voice of civil society, but the extent to which there is democracy within each party. In Chile, one of the things that we had to do following some scandals, including regarding party financing and so on, one of the major reforms that were undertaken is opening up the system of electing the leaders within each political party. So the whole notion of how political parties function and how can they be made more open and democratic, which is a significant challenge in my region, in Latin America, it's a key issue on that. And then there are obviously major advances that have been made, including in my country, in Chile, regarding the whole procurement process. That's another institution that tends to be captured. First, transparency is absolutely crucial, and putting everything online and making it contestable and subject to appeal. But also the system, how competitive the bidding takes place, it's absolutely key. And for now, last and least, because it's also a great experience in the case of Chile, meritocracy, the importance of instituting and having as part of the DNA of the institutions in the country that is meritocratic, be it the civil service, the judiciary, but very importantly also state-owned enterprises, how the boards are constituted, and the top executive on state-owned enterprises and in regulatory agencies. There's a commission which is totally independent, including outsiders from the public sector and government and other experts, that essentially provides 3 top candidates to the decision-making body, be it parliament or the president, regarding the top agencies. And that politicians, or those politicians, can only choose after that meritocratic system. Now, some allowance for the political process should be there, and the politicians should have been elected to power, should have the say, but they have to choose from that trio that is chosen according to meritocratic, just to suggest. There were so many thousands, tens and tens of thousands of political appointees. Whenever a government changed hands, political appointees went very low in terms of the totem pole of the civil service. Nowadays, that has been capped, and it's a very clear and limited amount which are political appointees. The rest is all on technocratic grounds. So these are just to suggest that the type of reforms in that direction which are very important. Last but not least, on political campaign finance. There is a major role that the public sector plays in providing public finance, which is equal across parties in terms of also access to TV and so on, to make the system more equal and less amenable to private influencing, and very, very strict caps and bans regarding private contributions to political finance. So it's to suggest the whole sphere of different areas where one would have to cover, but of course it depends on the particular vulnerability and nature of the capture in each country, where the homework needs to be done, which institutions are the most amenable to capture. The whole issue of state-owned enterprises and the reform of state-owned enterprises, the state of the art has advanced significantly in terms of what to do to improve. The issue is mostly at this stage nowadays not so much technical, it's political will. It's a political will to do it, to make them truly independent, commercialized. I reject and as an analyst, we have done a lot of homework. I reject the notion that the only solution is privatization. Privatization, if well done, in a particular form, it makes sense in some cases, but not in others. State-owned enterprise, if the reforms do take place, and then they can perform the role that they should be performing, and can be efficient. We recently, an assessment was done of over 80 state-owned enterprises in oil, gas, and mining around the world. And I'm very proud to suggest, and I didn't have any role in the methodology, that Codelco, the Chilean mining company, came out ahead of even Statoil, the Norwegian oil company, and others from industrial countries. So, and the state-owned enterprises from India, from other emerging economies, came out rated and assessed very, very highly. So yes, it can be done.
Yes, thank you. And then maybe you could just as well, now that you're dealing with the examples, these countries, and then just give us an example of Peru, because you had indicated at page 106 of the transcript that you would elaborate on that, on the position of the Peruvian state.
Well, Peru, it's another context that's been very dynamic, and they made some strides, unfortunately less than the potential that could have been. And number one, again, it's really important in Peru to recognize now the following. Yes, the president, up to about 8 months ago or so, up to recently, President Fujimori had to leave power, was basically sacked because he was associated with a major corruption and capture scandal started in Brazil under the car wash scandal, which I can refer the case of Brazil because it's quite interesting in that, and I had promised that if there's time and interest. But it goes to show first that some of these corruption and state capture nowadays is transnational in nature, and it's very important to always look at the role of outsiders in that, both enablers in our field, which is oil, gas, and mining, which is one of the areas I focus on. There are some commodity traders in the oil business who do not necessarily behave and act in the best interest of the nation where the oil, gas, and mining is being purchased, as opposed to some now more enlightened transnational, multinational mining companies that are operating at a much higher standard of governance, realizing that ultimately it pays for the country, but it pays in the long run for them. So first is to recognize this international dimension. That has become very clear. Recently, in the case of Peru, the president loses his job, but this is not a recent phenomenon. And again, it's really important to go back to history. Many people are focused during the military regime of President Fujimori, who also ended up in prison. So one can say some of the institutions do work because there's no impunity. I ended up in prison, and the system that he had with the chief of intelligence, Montesinos, which was a different type of capture because it started from that political intelligence elite, but then they were in cahoots with the top business elite, some in the top business elite. They also captured the media, which is a very important issue here, the freedom of the press, which is something we can relate to later. But in that context, even what happened under the military regime of Fujimori, and we're talking about the 80s into the 90s, already had antecedents of corruption under a previous administration, which was more democratic, but with fragile institutions, the President Garcia, where the particular relationship with the elite had already begun to take place. So already there was a history since then. In recent times, in the recent months, because of what has recently happened in terms of the scandal of corruption, which was a bit more transnational in nature, and because of nowadays the press is no longer captured like there was before, because of the civic space that is provided and the citizens demanding change, there is increasing attention to that by the top political leadership, who have begun to enact certain laws and policies to try to move forward and address these issues of corruption and capture. But this is incipient, and there one has to recognize that there is a deep historical background that has to be brought into play in understanding these issues of capture. They do not happen overnight, and they do not usually just happen under the one regime.
Thank you. And then from that answer, one gets the sense that from what you've told us, that there's different forms of state capture. They come in different forms and shapes, and one has to look at a particular form that presents itself before that particular country at that time.
That's
yeah.
right.
Yes. And then once then a country has found that it has been captured, what is the best way of dealing with it?
First, I would want to encourage a broader debate and discussion, because you know the case of South Africa better, what the notion of discovery also means. I assume it's not an overnight epiphany, but it's already a process of observing and basically also feeling the consequences of a particular types of misgovernance, corruption that may be taking place already for some time. And then it takes the work of a commission like yours, and I know that many academics here are working and so on, to fully unearth what are the major manifestations, what's really happening. And I know there were major reports issued late, or not so late last year, by the chief prosecutor and so on, and that's part of the process that one goes on. I know that in legal terms you have the notion of discovery, but it's a process. It's a dynamic process. Similarly, the response to it, which is absolutely crucial, and I commend you because it's for what you're trying to do, and this is such a historical opportunity here in that case. That has to be homegrown, and it has to draw, and I'm very pleased to have been invited here with also Joel Hellman having testified, and we can provide suggestions from the rest of the world, but it's more in terms of what they did, and they did in response to A, B, C, and D. And you would know best what it's applicable or not. I would start this as a way of thinking about the issue in terms of asking the questions regarding of what are the most vulnerable institutions that have been subject to capture and why, and what are the forces behind it. In terms of the forces behind it, one has to look, and I speak as an economist, in terms of the incentives. Why were these incentives for those that were trying, successfully or not, to capture? Why were they there rather than saying, no, that's not in our interest? As was told by Professor Hellman in our joint discussion from afar, or a few weeks ago, it is in our human nature, that's as part of researchers, we know that we try to influence others and influence decisions. That's true everywhere. The question is how to organize and regulate that influencing so that it is competitive, it's legitimate. There are many civil society groups, legitimate groups, that want influencing in one form or another that to take place that does inform the parliament, and that's part of a vibrant democratic process. The problem is when it becomes monopolized by the few that influence. And that gets into the very important issues of conflict of interest and lobby law regulations. So there's a whole bucket there that the country would want to look at it, any country, in terms of whether it's appropriate or not, to ensure a vibrant, competitive influencing. Not that one cannot eliminate the influencing. It's part and parcel. The same about the regulations and system of political campaign financing, because it plays such a key role. So that's another area. The issue of public service reform related to meritocracy, we just mentioned that, is another area of focus, and something that it was much focus in the case of Chile that has been dealt with. Then there are the issues around state-owned enterprises, which you did mention recently, and then, of course, the issues of judiciary. At the end of the day, progress in these, including, absolutely crucial, the freedom of the media, and as opposed to capture of the media, which has been a problem in many countries. The freedom of the media, coupled with the accountability that civil society leaders in the outside can demand from the public service and government, has proven crucial. And that has proven why in Chile, Parliament didn't have the incentives, the Congress and the Parliament, the lawmakers. Many of these laws had to be passed on political finance. It's against their interest. But why eventually they were adopted? They had no choice. There was such a groundswell of support and pressure from civil society mobilized and groups that look at what happened. And these are the recommendations of a commission. The recommendation of a commission, either we do it or we are out in the next election. And many of these leaders put them on notice. This, affects the voting. So those different type of aspects need to be looked at, but which ones are crucial in the country. But to end, what's absolutely crucial, all this can be happening, including transparency reforms, which are crucial, we haven't discussed enough. But if at the end of the day all this happens, but there's full impunity, then it has very little traction or impact. So how rule of law functions and the absence or existence of impunity is crucial. And that's what has made the difference, and that's why even with a lot of problems, Brazil is making progress. So they had a major scandal, the major discovery of the system of state capture was discovered because the judiciary had been strengthened, and there were very courageous investigators and judges that went out there and then unearthed the whole web of capture and corruption that involved the whole political elite, that their own personal human risk in much context. But it was because the judiciary had been strengthened. Associated with that strengthening was the adoption and use of plea bargaining. Plea bargaining as a tool for discovery and unearthing the whole problem in the system, and not just with one particular individual captors. Captors are not one individual. It's usually a whole web of systems. It could be a group of industrialists working together, or a group in the financial sector having met in the shadows for a very, very long time. So it takes one of them to tell the whole story. If there's plea bargaining, that's happening. We're witnessing this in another context in the United States, in the case of right now, of the Mueller probe. But in the case of Brazil, that was absolutely crucial. So there are all these type of innovations and reforms that different countries are undertaking. I am reticent to say this is one country with a great success. Of course, I'm proud of Chile. We still have challenges there and unfinished business. But it's very important to focus on particular areas where some countries have made enormous progress. The same country may not be making the same progress on other areas.
So in those countries where it has been found that there were these transgressions, people were brought to book, so to speak, and you believe that if that happens at the end of the day, after all the evidence has been laid, all the findings are made, that would be a necessary process to be undertaken.
If I can just have one comment. comment about that. Just as Mr. Chairman, as I just made the case that obviously where in settings where there is complete impunity, there can be enormous progress on the rest, but the country will have significant challenge. Speaking very frankly, I have been a student in this issue for decades, and I like to pair countries to study that share the same historical, cultural antecedents and so on. Chile and Argentina. Argentina was much richer, much better off than Chile. We have now crossed paths because of governance in other directions. Chile and Mexico are also, it's very interesting because in Chile, rule of law has been very, very important, and there have been improvements and strong. There was more reticence of having transparency reforms, particularly for a variety of reasons. There was much more anxiety regarding that. The converse in Mexico, who made many transparency reforms, while the judicial rule of law is, to put it mildly, a huge challenge. And that's why Mexico is not making the progress that it should in spite of those other reforms. Well, Chile eventually adopted transparency and so on. At the end of the day, it's not one that will work. So you said, you put it very rightly, rule of law versus impunity is very important, it's necessary, but at the same time will not be sufficient on its own. It has to be complemented by these systemic reforms that we're discussing. This is our observation in other countries. Maybe you come to a different conclusion in South Africa, but it has to be what happens with state-owned enterprises, what happens in any country, and what happens with the meritocracy in appointments in the public service, what happens with political campaign finance. All these other areas, if they are far, far behind, then they're going to be a major pullback in not allowing these reforms to progress, even if there's no impunity. So it's not just impunity or prosecutions alone.
Yes, and then you've linked the whole issue of transparency, conflict of interest with beneficiary ownership. Could you just elaborate on that?
This is one, and I'm glad you asked about that, Mr. Chairman. It's one example, potent illustration of the notion that that even if the country is not in transition, the whole legal, regulatory, institutional system in any country, because the world evolves so significantly, has to be in transition, has to be very dynamic and evolve with the times. In the old days, there was very little ability for the corrupt to engage in, through technology now, and other means in placing the monies abroad, in releasing the whole issue, illicit financial flows and so on has taken particular prominence in our modern era. It was not such an issue 30 years ago. And given the magnitudes of the rents related to state capture and the ability of many to appropriate that and put them elsewhere, that has been very important. All of a sudden, speaking about discovery, we get this major worldwide scandal, which I'm confident you are aware of, which is called the Panama Papers disclosure. And where is that provides a major impetus for many in our realm and others who are pushing for a long time to have much more disclosure and much more transparency in who are the real owners of the major corporations, enterprises, activities, and also those that are bidding for licenses for the gems of the country, whether it's in mining or in oil and so on. So we have been asking for a long time for full disclosure. One of my roles is also to sit as a member of the international board in the Extractive Industry Transparency Initiative, which has more than 50 countries. There's a hope that someday maybe South Africa would wish to join. But it's helping with the norms regarding full transparency, accountability, and governance in the oil, mining, and gas sector. across the world. So there was the push to try to have much more disclosure regarding who are the real owners that benefit from all these deals, which is very important for anti-corruption and for mitigating state capture. There was a lot of resistance. Panama paper scandal happens, and the resistance had to be much more muted, and there was a big push, and therefore new regulations and requirements. In this case, it's a requirement globally, but every country decides whether to adopt it in the law or not, as to have full disclosure of who the actual owners are, and through that, one ought to be able to see, well, are there very high officials, high-level politicians that are involved in these commercial oil licenses, and are they related to the Ministry of Oil? This is just an example. So what's called in international legal lingo the PEPs, the politically exposed people, there will be a major progress regarding that. This is to illustrate that there are certain innovations regarding laws and regulations that happen over time, even in a country, irrespective of how robust the original constitution and set of laws are. The same applies to anything related to technology. Obviously, the laws and regulations regarding that have to be adapted to a completely new era nowadays compared with 50 years ago. So there are all kinds of innovations there. But regarding the public disclosure registries in terms of every country having it, vis-a-vis their beneficiary owners, both of the company, but also for the licensings, which are where the rents, licensing on natural resources which belong to the people. So if you're going to get a license, one wants to know who is bidding, and of course transparency about the contracts and transparency about the payments that are given to government. That's one of the major progresses that has taken place over the past 10 years regarding transparency and beneficiary ownership. Is evolving still, and many countries have not implemented, but it's one of those.
Yes. And you had referred us to the emoluments clause that exists in the United States. Could you just mention that to the chairperson, which deals with receipt of gifts?
Well, that's a very particular case, that is a legal case that is taking place right now in the United States. And emoluments clause, it's a clause that comes in the Constitution by the original writers of the Constitution of the United States. We're talking essentially 250 plus years ago, that were enlightened enough to say that no holder of high office, including the president, shall be allowed to receive any gifts from any foreign entity, particularly foreign government, or even officials of the different states of the United States, the governor and so on. So there can be no undue influencing either from abroad or even from the other state, for both national interest, but national security, but also in terms of probity and integrity. There have been many question marks and issues that have arisen under the current leadership and administration in the United States, and one of them is the undue influencing of commercial business interests that may be tainting the public, the decision-making by the top leader for the public good. So as a result, the leadership of one state, the state of Maryland, and some former officials of US administration, we happen to be the ethics czars, in charge of ethics of both, in one case, a Republican administration, President Bush, and in the other case of Obama administration. They're both jointly in this case, basically trying to bring to trial for the president for violating the emoluments clause, because the president, supposedly, according to the allegations, had been benefiting from his own investments that he does have in the United States, and particularly example is the Trump hotel in Washington, D.C., which is close to the White House, supposedly or allegedly may have received basically foreign guests and have, as well as leaders of particular states, and as a result benefiting from those. So that's a case. It's moving through the courts, and of course the last thing is for me to comment on how it may end up. It's just coming, but it's to illustrate for one that the Constitution can be very robust and work, and it can be used also by the legal system and the court to respond when there is a alleged case of misgovernance or corruption or state capture, however it's labeled by the law of the particular country, so that there is a response. So this is just one illustration that sometimes the Constitution can be helpful in this context.
Yes. And then maybe just on that issue of transparency, just the example that you gave us the other day of you having invited someone over to your house and the restrictions on what to offer that person and you know the extent to which you can go as a host you know to make your guests comfortable.
It's a quick anecdote, but also I'm glad you asked me this now, because it's too easy right now to be totally critical about one country or totally effusive for another. That's why I was being also cautious. My own country, Chile, we still have our challenges. In the case of the United States, there are enormous strengths, institutional strength that should be commended. And that's part and parcel of governance in a country. No country, in the definitions I give about governance, the good governance, absence of state capture or of corruption, that doesn't exist, and therefore that's not the definition, absence of corruption, that doesn't exist anywhere, that should be equated with stellar governance. Good governance is when challenges happen, that do happen everywhere, is the ability of the system, the institutions, the rule of law to respond to it. And that's what we have done in Chile. In the United States, for better or worse, that's happening. There are going to be midterm elections and so on. And where it's very serious in the United States, it's the rules and regulations and laws around governmental ethics, governing public service. And just as an illustration, they cannot receive gifts from the outsider. When I was heading the World Bank office in Ukraine in the early days of transition there, I invited a very high-level official of one of the agencies of agriculture. We used to be in the World Bank before, so I knew him. I invited him for dinner, and he said, I can accept dinner as long as you promise that it's not going to be a very luxurious dinner, because I cannot accept even in kind anything that would exceed the cost of $50. But it's just to illustrate that in those systems that is part of the DNA, even if at a higher level there may be attempts at capture, as we have discussed.
Yes. And then maybe if you could just deal briefly with the cost of state capture to a country. You've dealt with this in your report, and we have a section in the slide. If we may just go back to the slide. You've just put up 2 examples. Could you just go back to that? Sure. Okay, thank you. The first slide. Sorry, the first one. First slide.
You're waiting for me or for the slides?
No, the slide is going to come up. Sorry.
Oh, the slides are
yes.
Come up, okay. Yes. So you already summarized it very well at the beginning. In fact, in the next, if you had shown everybody a slide after that.
Let's see, which one is it? No, the slide. Let's go down. Sorry.
Keep
Yeah,
going.
that one. Yes, thank you. That's the slide.
That's one slide. And
that's one slide, yes.
Yeah.
Yes.
That slide does come from us. The rest
yes.
was your excellent work. Miss Norman, excellent work. That is from our original work, one of the summaries of the data, which we did summarize in the earlier hearing that we had with Professor Hellman present, it is also fully explained in the statement. So all what I'm going to suggest here, the enormous difference in the height of the two sets of columns reflect what happens with the dynamism or lack thereof of the whole private sector and also more generally of the economy in countries that manage to avoid state capture versus countries that exhibited state capture. These are among the post-socialist countries in transition. So out of those 27 countries, it's a ratio of 2 to 1 in terms of the growth of the private sector, who are not the captors. The captors, that small elite, manages to benefit particularly in a captured setting. And that's because they buy, essentially, that influence. But it's at the expense, as we see in the graph, of everybody else. And it's much less growth, there's much less investment, and there's much less revenue for the company. And importantly, which is not in this graph, and as I mentioned before, there's much less protection of property rights for the regular company, the regular firm, which is not the captor. The captors buy their own, they privatize, they buy own protection of the property rights, and they do well. And they do, in fact, 5 times better in terms of the extent of protection of property right than the non-captor firm in countries that have been subject to capture. The others, countries that have managed to avoid capture, do well, very well in terms of property rights. So that's one aspect of obviously the cost. If you can go to the next slide,
yes,
to broaden the discussion, that comes from separate work, which takes the whole world data that we have had and we have monitored, and we have a set of indicators that we started developing already in the 90s for 20 years, which are called the Worldwide Governance Indicator, with my partner in these since then, Art Cray. So we can use the data from throughout the world about governance, including one of the dimensions is control of corruption, which also includes capture. So this is more general. What happens in countries that over time have exhibited high corruption versus medium-level corruptions versus low corruptions? There's an extreme difference in terms of the levels of well-being of the population between those. And that gives a sense not only about the cost of corruption, but also about the promise and the potential payoff, we call it dividend, of improving governance, controlling state capture, controlling corruption. And just to give one point of data, which is part of that research, a country that decides to embark on serious governance, institutional reforms to tackle corruption and state capture in a realistic manner, which doesn't mean no country can go from being the worst in the world even in 5 years to being at the top. A realistic manner is basically traversing about 1/5 of what the distance between the worst and the best of the world, which is totally realistic in statistical terms, is 1 standard deviation. So a country that improves realistically, significant reforms, but realistic improvement, that's associated with an improvement in per capita income for every citizen, if it's distributed, okay, by 3 times. It's a tripling of income per capita. If the country has income per capita of $10,000 per year today, can expect in the long term, it takes time to reap the benefits, to have $30,000. So that applies to income per capita. That also applies to, we have seen it in the data, and it's causal. It goes from improving control of corruption to these impacts. It's lessening of inequality, lessening of illiteracy, better education gains, and also, very importantly, much better investments. As I said earlier, and that's associated with research of others, I'm not in that field, it also strengthens national security of the country. The whole issues around also migration, national security around corruption in security services and so on is very important. And lastly, but not least, as mentioned, it also improves much the prospects of democratic institutions. So it has a major also very healthy political dimension.
Yes. And then you had mentioned in your statement recession in Brazil, in the case of Brazil, am I correct? Yes.
Well, thank you for the question. And Mr. Chairman, that's a flip side of, I just tried to put it in perspective,
yes,
and very positive terms. What if a country does it? But a country that has been enmeshed on this corruption, and indeed what we show in our research is the longer term, medium and longer term impact. But nowadays, particularly when a country goes downhill in terms of corruption and state capture, the impact is not in the long term. The income can be very, very large, and it can be in the short term, and it's not only about general well-being objectives, it's also about the basic macroeconomic financial indicators. Budget deficits go up, financial crises ensue, and the rate of growth of GDP comes to a halt very quickly. Brazil, in fact, for the first time in an extremely long time, after a very robust period of growth, entered a recession, of which they are now trying to get out. They're just barely back to zero growth after being in the negative territory for a couple of years as a result of what happened. In Peru and some other countries, because of the transnational nature of these major state capture events, there have been a major impact not only on GDP, but on the paralysis, the sudden halt and paralysis of infrastructure investments, since much of the capture was associated with construction and infrastructure companies and so on, in some cases that have come to a halt. So this shows in real time and concretely on the ground that this is not just abstract numbers, is of what's happening, and that's a major cost for the middle class and for the poor that ultimately it takes the brunt of this problem. At the financial level, one more comment. This has become such a serious concern and issue that the International Monetary Fund, that in the past was not very focused on these issues because their remit was short-term financial issues. So corruption, state capture was a bit more foreign to an organization like that. The World Bank was dealing a bit more, was dealing more with that. But now the IMF has taken significant leadership and concern on that, and they have coined a new term for this, for the impact, potential impact of state capture and corruption in a number of countries. They call it macro-critical. I've mentioned that before, given the concern of that. And this is an example of that. Brazil was emblematic case for these type of organizations, and looking at it more international, that this can have a major impact for the whole macroeconomy of the country, which implies major impact for the poor and the middle class.
Yes. So in summary, with that, with the last slide, that the sooner you act on any suspicion or allegations of corruption and state capture, the better for a country.
Obviously, yes. It's incredibly important, as mentioned before, the role of the judiciary, and not only that the proper prosecutions take place and there's no impunity as a result, but it's very important that it sends such a clear signal to the population, also to investors abroad and so on, which plays then not only an enforcement role, but a deterrent role, because the more that there is no impunity and there is a real sanction involved with acting in this form, the less that you're going to have those type of cases in the future. At the end of the day, We're all humans. We all make cost-benefit calculations. Is it worth it or not? Of course, we have our ethics too, but incentives play a key role. Nowadays in the United States, and again, talking about the strengths of the United States, you're not supposed, and by law, you cannot evade taxes, okay? Only about 1% of the taxpayers are audited, because these are millions and millions, it's extremely expensive and so on. However, if you're audited and you're found to have evaded, you go to jail, and you do. And politicians and others, and right now in the Mueller case, there are some cases that how they're doing it. So as a result, the extent of tax evasion is not very large in a country like that. So it's not that you need to be auditing everything like that, but rule of law does work, and people know here there is a sanction. One doesn't mess around with that. So it's just to exemplify that it does. It's very important that the judiciary is functioning in any place, and there's no impunity, because it also plays a deterrent role. At the same time, as a lead off from your question, it's absolutely crucial in any country to also embark and make progress on the complementary issues and reforms that are absolutely essential, because no single progress on just one dimension is going to make the difference alone. And that's only for you to know regarding South Africa, in the systemic sense, how much, whether issues regarding safeguarding the budget from being looted, what needs to be done with state-owned enterprise, what needs to be done with political finance campaign, what needs to be done in other political realms. What I was telling about Chile, you would know best. It would be my hope. This is such an impressive initiative that you have all undertaken, that this also creates the space to discuss not only the issues of prosecutions and the very, very important but narrow legal issues that you're discussing, but to have the space of discussing more broadly what's absolutely essential as well in other realms regarding addressing state capture.
Yes. Thank you. Thank you, Mr. Chairman.
Thank you very much for your evidence. Would it be correct to say, in the end, the whole idea behind anyone who might be wishing to capture a state is to have influence on certain decision-making institutions and functionaries within a state, so that ultimately they may have financial or business benefits, or are there other motives or goals?
Very important question, Mr. Chairman, Mr. Deputy Chief Justice. Obviously, from our experience in other places, the traditional and boring answer is going to be both. The whole issue of financial motivation is obviously a very important driver of human nature for reasons that you know better than I do, we all know well. But that's not the only motivator. We're also obviously, we collectively and in different degrees, driven by power. There are many people who accept to serve in public service on positions of leadership, and they're not full integrity, and I've met so many in so many countries, and that it's not for financial gain, but to have a major influence in policymaker and that power to do so, but for the public good. It's a very important driver. Many of us in think tanks, academics, I head an organization which is an international institution of that. We also advocate with evidence for improved governance, transparency, in natural resources for the benefits of the citizens of the country. I come from Chile, my colleagues come from all over the world. We want ultimately all the benefits. That drives us, and that drives many of you in public service at all. So the financial motives is not the only thing that obviously it drives it. That's the first point. But even if the main driver, particularly by those that want to capture for their own financial benefit, is purely financial and economic, it makes a very big difference if that's in the context of enormous competition in terms of lobbying and political influencing, or it's in the context of the political influencing. The extent of that political economic influencing by the few has become monopolized. The moment that has become monopolized, and it's the relationship between the few in the elite, in the economic financial elite, with the top political leadership or with the lawmakers in parliament, it can be extremely damaging and distorting. But as I mentioned at the beginning, the intention to influence, it's part of human nature, and many organizations and groups do, and we do it in the voting booth every time that we vote also, and we're trying to influence. That's legitimate. But that's why it's so important to look at the extent to which the whole system of political influencing has been distorted or not, whether via political campaign finance, via the way that the political parties elect and monitor their own leaders, and by the issues of conflict of interest, lobby laws, all what we discuss. It's what's important. In short, one cannot ban by fiat influencing. That's in the human nature, but one can regulate it and ensure that the system put in place, which is not just through laws, but institutions and so on, provides more of a level playing field regarding such influencing. Emblematic case, this exists. Emblematic case are obviously the Scandinavian countries. They do have a social compact among the different, with the whole population of what's legitimate and how to move forward, and a certain modicum of equality, both political, economic, and so on. Canada is a very interesting case that has made significant progress in those. So these models and these systems is not at an academic level. They do exist, and they have achieved consensus in how to move forward. And at a more practical and micro or institutional level, if you allow me to mention exciting initiatives that are taking place and innovations in this day and age in many countries, refer, and you had it to your Reconciliation Commission, which in Chile, there was a lot of mutual interest because we had our own after Pinochet and so on. There is increasing effectiveness and interest in multi-stakeholder type of institutional arrangements to reach consensus about key issues in society. So about improved governance and anti-corruption in natural resources, we have this global initiative, which is Extractive Industry Transparency Initiative. This is where we have to agree among the key representatives of government, of industry, of investors, as well as civil society, think tanks, and so on. And something happens when this is done in such a consensus form. It is my measured sense that in the context of improved governance and corruption, it's really important when these initiatives do embrace and involve also this multi-stakeholder nature, engaging civil society, the leaders in think tanks, as well as the leadership in industry itself, the enlightened leadership. Every country does have that, and we have been witnessing some from the banking system and others. In no country, it's just that this whole group, they're all tainted, and so on, and others. They are leaders with integrity and reformists among all stakeholders, just like there are others who have other interests. But it's very interesting and important how these multi-stakeholder initiatives can also make progress. And through the commendable work of your commission, if that could be also perhaps a venue to engage in that discussion, and which in some other countries that has allowed for a broader type of consensus regarding the need to move ahead for these reasons. I'm not mentioning or referring at all to the legal aspects of that, which you have a very particular mandate and you know best. But from my experience in many other countries, the whole notion of moving forward, whether through one commission or separately, with a multi-stakeholder dynamic discussion and debate, and trying to arrive at consensus in society with that, it's something that could, in the case of Chile, we have done it in the case of anti-corruption recently and so on, and there are other such examples.
Now, you mentioned that in your research, you found that in some cases of state capture, what happens is that certain groups want to change the laws and the policies of government so as to suit their ends. I would imagine that in a case where it's difficult to change laws in terms of the constitutional and legal system of a particular country, they might want to look at people who have power, people who serve in certain institutions of government, people who occupy certain positions of government, and therefore seek to ensure that it is people that can do what they want them to do. Does that sound consistent with your experience in terms of research?
Yes, indeed, Mr. Chairman. One of the vehicles of capture, in fact, rather than the indirect influencing from still staying supposedly on the outside of government, but through political campaign finance or through other illicit means, bribes themselves and so on. That's one way, but the influencing on who would be in a high position of power and who would be in the cabinet is obviously such a form. In some countries, it's no secret. In the post-Soviet era, there was even an informal price tag associated with how much a particular ministry, capturing it and putting one's own person would cost. And it was interesting to see the differences across ministries, which was again related to the question of what are the most vulnerable sectors where rents can be accrued. If the country was oil rich, obviously Ministry of Oil versus the Ministry of Agriculture and so on. So the answer is yes, unfortunately. That is one of the vehicles, one of the mechanisms by which that can be accomplished. But let's keep in mind also that, some countries go through increasing sophistication, development, and so on, like many countries here, and so on. So over time, the form of corruptions and the form of state capture morphs, changes, that. So they evolve over time. So at a particular vulnerable time, in terms of the institutions, they may be placing directly the cabinet ministers. In some cases, some of the oligarchs, quote-unquote oligarchs, become the leader of the state themselves. It has happened too. Then over time, governance institutions evolve, they strengthen, But that doesn't mean that state capture necessarily disappears. It takes a while, but then other forms which are more subtle through the political finance context and so on take more prominence. The ability to adapt and see opportunities obviously should not be not only be a major priority for reformists, but unfortunately is also what the other side is always looking, how to adapt to the new policies and so on that are trying to counter those forces of capture.
You spoke also about state-owned enterprises and that they can be a target for state capture. And from what you have said, it seems that you would be saying to us that, talking generally, to the extent that state-owned enterprises could be easy targets for state capture, that it would be important to ensure that the legal framework, for example, for the appointment of boards of those state enterprises should be strong and transparent. Maybe the appointments should be very transparent so that in that way one minimizes the prospects that somebody, one person, may just put in all the people that he or she wants to put in if all the power depends on one person to constitute boards of such entities. What would be your comment on that? Is my reading of what you say correct?
Absolutely correct. And that's a paramount and one of the main concerns in a number of state-owned enterprises we have looked at around the world. I would even extend it, not only about the board is crucial, how the board is appointed, but then, and I would add to strong and transparent, even if it's embedded in the notion that you just said of strong, the explicit notion of meritocratic. So that's extremely important. I would expand it also to the chief executives, to the top executives of the state-owned enterprises, and then the regulations and laws that govern the independence by which they can operate. The clarity of their remits is crucial. Deliberately, many of the state-owned enterprises, the remit, it's either unclear even in the books, or even if it is in the books, it's not followed, and they take over the production and regulatory remit at the same time, when there should be total worlds and should different institutions taking it. Just to illustrate that does happen in the oil sector, where major state-owned enterprises take both remits on that, and that creates all kinds of misgovernance and potential conflict of interest. And there are many other such issues that need to be clarified. Transparency also applies to their financial accounts, it's state-owned enterprises, so that everybody can monitor that. So you are absolutely right. It's like what we were discussing before as to how to tackle state capture more generally. These, what you just mentioned and referred in my testimony regarding the appointment of board, is crucial, but ought not to be seen as the silver bullet on its own alone. Necessary, but not sufficient, and the rest of the homework, of course, will depend on the diagnostic of each country and state-owned enterprise, but the rest of the homework in these other dimensions is very important as well to complement that initiative regarding the board appointment.
Well, I guess you may or may not say the same thing with regard to the appointment, for example, of directors general in different government departments. Now, in South Africa, directors general, I think, generally would be appointed, I think one of the witnesses told us by, I think, the president, at least at a certain stage, it was the president. I don't know if at another stage it was the minister, or there was consultation between the two. But the Director General is like the Chief Executive Officer of the Government Department. It would seem, based on what you have told us, that it may well be that if the appointment of Directors General happens in a certain way, that might encourage state capture, but if it is done in a certain way, maybe very transparently and so on, maybe it might not. So I just want you to comment on that, or whether you would limit what you said to state-owned enterprises in terms of boards and their chief executive officers.
That's an excellent question, Mr. Chairman, because we have to acknowledge that it becomes more nuanced regarding senior level appointments in government, because there is a legitimate political process. There's a reason why a particular leader with a political backing is elected into power, and that's a part of the political process. And then every country differs. There's a legitimate question, the extent to which those appointments and how far down should be of a political nature, and from where it's absolutely crucial to safeguard the integrity, meritocratic technical integrity of the civil service. And that should not be. That's the consensus in terms of best practice around the world. That should not be touched by the political process. There was a time I studied this issue in particular depth many, many years ago. So this doesn't reflect the current era. But there was a time 20 years ago when I looked at this issue, say, in countries like Bolivia, small country, government change, 60,000 civil servants and public officials were changed as a result of change. In Japan, at the time, the mandated changes were 18, just the ministers, for political reasons. So, and of course, the reality around the world is somewhere in between. And that's very different in state-owned enterprises that basically has to play a certain role in terms of maintaining and safeguarding the independence and functioning in an efficient and commercial way. Otherwise, it can be an enormous drag, economic and social drag on society. It's paramount that, because at the end of the day, that's the difference. The last word is state-owned, but it's an enterprise. If it's going to be an enterprise in this day and age and not be a major drain ultimately on the taxpayer that pays for that, that's absolutely crucial. So, but having said that, in terms of director generals and even those decisions that are decided to be political decisions, certain systems allow for that having an integrated degree of meritocracy in it. So at the end, the minister or the leader of that, basically they want to make a decision which has a political dimension. But, okay, I want to see the top 5 candidates that would come from a meritocratic system, and then among those top, I may have a political dimension of that, but at least choosing within a cadre of the most very highly qualified people with different dimensions and so on. So there are ways of integrating these with the political reality of any country and the political imperatives, but saying, but I still want to get the best possible person. So I will look at that list rather than having my person done in a way. The other question, and you raise it with state-owned enterprises, the more transparent the system, or that it will encourage then even if the ultimate decision has a political dimension, but it will encourage more credibility and more meritocracy in that ultimate decision made.
Do you have anything you can say about what you think could be done to protect for example, a director general who is opposed to doing wrong. When, for example, his or her political master wants them to do something wrong. Now, if the Director General concerned, his or her continued employment as Director General really depends just on that one person, then there may be a risk of losing the job, and therefore that Director General doesn't get protected. But at the same time, one may have to look at what you have said to say, well, maybe Directors General fall within a certain category of persons where somebody in political office should be given room to put in whoever they want in order for them to achieve their goals in government. But I'm just wondering how one would balance the two to try and make sure that there is a framework or an environment that encourages Directors General to say no to any attempt to get them to do wrong, or to say no to state capture without being vulnerable to losing their jobs or being changed from one department to another, maybe for no good reason.
Again, Mr. Chairman, very difficult, and to again backstop the point that I'm not an expert in South Africa, and I know you're asking in general, but just showing my own ignorance. When you speak about Director General, you're referring within the ministries. Not a particular outside agency or something like that. We're talking within the
ministry.
Yeah. Okay.
Yeah. In our system, a Director General is within a ministry, right. So it would be the President, the Deputy President, right. The Minister, then the Director General, and the right. Director General is basically the head of the administration of the department, whereas the Minister is. Right. Political head of the department.
That's clear, yeah. In other countries in the region I've worked on, there have been permanent secretaries. Others they are undersecretary in the United States or vice ministers and so on. Clear. And that makes the answer even more difficult. But in general, obviously a traditional response in this, but it has been full of challenges in the implementation, is whistleblower protection. The whistleblower protection is one of those examples where it's not that difficult to get consensus to adopt it and to put it in the laws and the regulation, yet at the end of the day, through loopholes and the way it's implemented, it doesn't necessarily end up fully protecting the whistleblower, even if in paper or in principle that may be the intention, that a person or that functionary who is under pressure may have serious doubts whether he or she will be indeed fully protected. So the first question is that any country would want to undertake, okay, how is our system of whistleblower protection, and not just what's written in the law? How is it being implemented, and do we know for a fact that it has really, truly protected? And that would have to imply that there could be no retribution, no sanction, and that would be, if there was retribution or sanction, that would be subject to high penalty for those doing so. Because again, we get back, and that's a second comment, to the issue of rule of law and judicial working. Ultimately, and I know that's where you seem to be going with the question, you would not want that undue pressure from the higher up to the permanent secretary or to the Director General to do the wrong thing. So what we want, and that's what we've tried to do, like in Chile and many other countries, to get to a situation where the Director General is capable of saying, do you know that if I do that, we both may end up in jail? I mean, so that's where the issue of penalty and sanction being really there. This is, by the way, the response at the international level, and I know I'm taking the waiver from the Director General, but I think the parallel applies. The response that many in the early days of, again, United States, some kudos in this case, the Foreign Corruption Practices Act, when it begins to be instituted and basically barring foreign bribery from the US at first, then it gets expanded to by all OECD countries. Then when international executive would go to a country and a high official would say, yeah, well, we can do this deal, but you have to give me this or that under the table. The response was, you know that if I do that, I'll end up in jail, and you may end up on that. So that to make sure that a serious sanction for even that type of pressure and action would be an important deterrent, so that the Director General not only has to think, do I whistleblow or not, but be able to say, look, you know what will happen if we do this.
Thank you very much. Ms. Dobman, you are done.
Yes, thank you.
Yes. Okay, is it you or is it Mr. Pretorius who will tell me what is envisaged from now on?
Mr. Pretorius will. Thank you, Mr. Chairman.
Okay, thank you.
Thank you, Chair. The application in respect of at least one of the applicants will be heard tomorrow by arrangement at 10 o'clock. You should have or will shortly receive documentation in that respect. And thereafter we will announce the program for the following week.
No, thank you. Thank you very much, Dr. Kaufman. You have given us very useful insight into the issues of state capture, and I have no doubt that we will be enriched by the evidence you have given, and there may well be further communication between the legal team and yourself. Thank you very much.
Thank
you.
You
are excused. Thank you.
Thank you, Mr. Chairman,
Thank you.
for the opportunity. Thank you.
Thank you. We will then adjourn until tomorrow at 10 o'clock. I will then deal with Ms. Lynn Brown's application. That should not take long at all. And then we will announce tomorrow, after that application, what's going to happen for the rest of the week and next week. The proceedings are adjourned.
I think so. Tandy,
Thank you so much, Vincent. Sorry. Okay, thanks. No, I'm gonna. He's gonna have lunch, I think, and then the doctor is leaving. I think he has an interview. So whatever stabilizer that is arranged, I think some tip station. Yes. I'll establish that.
On a le tape. Hello. Hey, can you see me? Yeah. Yeah. You're about to go. Good afternoon, Zinga. Mike Brown, the CEO of Nedbank, went into details, taking us through a timeline of what happened from the time they decided to close the account of the Gupta-linked companies. He mentioned that the reasons why they closed the accounts was because they had a contractual right to cancel the account, given that each and every customer as well can terminate the account. They also have a right to give notice to a customer and then close the account subsequent to that. So he mentioned that they also took into account the adverse media reports that were doing the rounds, given reports about the Gupta businesses and the negative reporting about them. He also said the statement by the former Deputy Finance Minister, Mcebisi Jonas, that he was offered a ministerial position by the family, and it was released on a National Treasury letterhead. That was a big issue for them. Following that, KPMG, as the auditors for the Gupta-linked, for the Gupta companies, dropped them, and Sesfin also, as a broker sponsor, also dropped them, and that was, it presented reputational and business risks for them as a bank to continue working with them. After that, he said they issued a letter, a notice. They called a meeting with a Gupta representative to discuss this issue, to issue a notice that they will be terminating the account. A meeting that was attended by Mr. Howard, who refused to take the letter, and the letter was sent to them by registered mail. Following that, they received an invitation to attend the meeting at Luthuli House. At the meeting, he said, they mentioned that they could not go into details of confidential clients' information with them. So he said at Luthuli House, they, as the bank, they did not feel pressured as to the direction that they should be taking, or maybe reversing their decision. But then after that, they were also, like the other banks said, were invited to a meeting by an interministerial committee. What is different about their encounter was that they were made to believe that the finance minister would be at the meeting. And they went to the meeting. The finance minister wasn't there. When they raised the question as to where the finance minister was and why the meeting was held without him being the custodian of banking regulation, not being there, they were told, no, the minister is aware of the meeting, and he just could not make it because it was an ad hoc meeting, so to say. But he said that at the meeting, he felt pressured in a way that there were some veiled threats that were made as to the chairperson of the meeting, who that was the former Minerals Resources Minister, Msebenzi Zwane, who mentioned that he felt that the other banks who refused to attend this meeting, remember there were testimony from the other banks that said, like FNB yesterday, that said they refused to attend the meeting, they declined the invitation to the meeting. He said Zwane did not take kindly to that. He said they did not seem to respect the interministerial committee, and they should be attending the meeting with government because government issued licenses, banking licenses. So he said at the meeting, he was asked if perhaps Nedbank couldn't step in to save the jobs, provide transactional banking, be the primary banker for the Guptas, so as to save the jobs that they said were online since they couldn't pay salaries. But he said Nedbank could not do that. They were not going to change their decision because the risks which they listed as the reason why they were closing their accounts were still a threat to their business. Zinga?